Maybe please the script
Yes.
with the function of the others. I take mention number 14 on
1-4.
I'm neither people accommodate. Senior concern Mr. R.P. Sharma will be arguing it. Let the case be fixed on 9th of April. After
What is this matter about?
the declaration of third.
Pranjal Datta.
Yes.
19th matter.
Yes, ma'am.
If we have to fix a date, this is the old matter.
Yes.
Which date? 23rd.
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 Is a fixed item.
Wow. 3 S. Dihiya, learned counsel for the petitioner, has prayed for a little accommodation so as to enable him to engage a senior counsel. Full stop. Sri K. Kulita, learned counsel, is present for the response number 228. Full stop. Para. Considering that this writ petition is of the year 2019, comma, list. The matter is adjourned to be listed on 23rd of April for admission hearing.
I live. May please the Lord. Prospect action number 11. And after application
11, finance, 19 matter, why are you adjourning?
personal difficulty.
A prayer for adjournment has been made on behalf of the petitioner. Full stop. List on 22nd of April. 22-4. Yes. Item number?
5.
5 is a 17 matter.
Yeah,
When was it filed?
in January.
That we have understood, but
I have a contact.
who has filed the affidavit? Health Department. It has been submitted on behalf of the petitioner that a counter affidavit by the Health Department has been recently filed. And since the petitioner is on maternity leave, comma, the rejoinder affidavit could not be filed immediately, full stop. He accordingly, and then accordingly, some time is prayed for. When? List on 26th of April, by which time the rejoinder affidavit is required to be filed
Hello. Maybe the
for admission hearing, 26 for admission hearing. Yes,
I the contact.
yes. Yes, what is your prayer? 19 matter, why? John, why?
Actually, the contact of R. Hazarika is out.
Who? R. Hazarika. APSC Taxation Department have been.
So we have, I have taken person.
Okay. It is submitted that Sri R. Hazarika, learned counsel for the petitioner, has some personal difficulties. Para. As requested, comma, matter is adjourned to be listed on 22nd of April.
What's the name? It's
20?
26.
25th of April, 25. 25-4.
Deep your blood.
20.
Yes.
Yes.
It's
Cooperation Department.
Got it.
Okay. Sri G. Bodole, learned standing counsel, Cooperation Department. Prays for time on the ground that instructions are yet to be received. Full stop. Para. List on 26th of April. Listing. Bench tree matter. This is the second bench tree. You have to go to the first bench tree, not here.
Item 44 sublease.
But actually, I filed an application seeking improvement. Now I am told by my landed friend they would like to withdraw the report.
Let him be impleted, then you withdraw. No, just on a lighter vein. Heard Sri K. and Chaudhary Lanasine Council, assisted by Sri D.J. Das, for the applicant, who by means of this application has paid for implement as party respondent in the connected writ petition. Full stop. Sri D. Mahanta, Learned Council, appearing for the opposite party writ petitioner, however, submits that there are instructions to withdraw this writ petition, to withdraw the writ petition. Full stop. Para. Considering the above, comma, the writ petition stands dismissed on withdrawal. Full stop. Accordingly, the IA also stands disposed of at our order.
So the earlier interim order stands vacated.
Para. The interim order passed earlier stands vacated.
But liberty may be given. Liberty
For what?
for filing, but if necessary, but still Neta may have promotion.
If there is a cause of action, you come. Why
But
should we?
if-
Itu eta order diba? WPC? আই অলপৰ লেখাটো অলপ বেলেগ কৰিম হাৰ্ট শ্ৰী ডি মহন্ত Learned Council for writ petitioner and so and so NDIA তাৰপিছত ক'ব NDIA so and so has filed for improvement আৰম্ভণিটো writ petitioner ৰেডি কৰিবা yes
Item 1.
who is your senior
But
what is the matter 16 matter
yes,
what is this
it's a
matter?
matter of appointment and selection and appointment of different table participants for the regular table participant.
Okay, we'll have it after some time. Ask Mr. Nath to be here. Is there any alive cause of action, existing cause of action still?
Yes.
Okay.
Item 2.
Mr. Bora? what is
Well,
this?
a matter regarding correction of date of birth. Petitioner was a underqualified stenographer in the Arctic court. Your lordship will kindly peruse the first order dated 31/5/2007.
Just a minute, please. We take it for final disposal?
Right.
17 matter. Mr. Kolita for whom?
Arctic.
Artfed.
And for responsibility, Artfed is not a party.
Who's Artfed then?
Responsibility, managing director of art.
Two details. 3 and 4. 4 is the deputy general manager.
You're for 3 and 4. Okay, doesn't matter. Okay. Yes.
Lordship will kindly peruse the order dated 31/5/2007
Of this court.
of this.
31/5.
31/5/2007.
The first order.
Right.
Okay. Please read.
The petitioner has joined service in the Assam Apex Weavers and Artisan Cooperative Federation Artfed on 16/6/1994 and the stenographer is aggrieved by her retirement with effect from 31/7/2007. under the impugned judgment, impugned order dated 7/3/2017 of the Managing Director of Arctic. Mr. T. Boda, the Arnett Council submits that the petitioner's date of birth was incorrectly recorded in the service book as 1/3/1957 and also in the SSLC certificate issued on 11/6/1978. Therefore, the employee applied on 6/9/2013 for correction of her date of birth as 3/9/1993. To justify the correction, the applicant had produced her Janam Kundali and also sworn an affidavit. But it is submitted that those have been ignored and the petitioner is made prematurely retire on 31/2/2007. On the basis of date of birth 1/3/1957 as recorded in her service. Correction of date of birth at the fake end of service area is not permissible under SR 8(a), but Mr. T. Boda, the Learned Council submits that in the instant case, the representation was filed on 6/9/2013. Around 3.5 years before the scheduled retirement on 31/3/2007. Therefore, notice has been issued and they have filed their reply also. Your losses may
Where is your matriculation certificate?
Madam, I have annexed, madam.
Why Janam Kundali? You are a stenographer.
My lord, that
You belong to
Correct.
which period?
We-
Maurya dynasty or Ahom dynasty?
is 18 and 19. My lord, at that
You
time,
don't
no,
have
no
DOB.
birth certificate was issued at that time. They have entered the records, therefore Seva has been made a party.
You did not appear in matriculation.
Yes, my lord, I have submitted my birth certificate, page 19B,
Page 19.
19, Annexure B. Because that was from the office, my lord, school office.
Yes, 21 years on the first day of March 1978. What is your date of birth?
My lord,
If you
I have
What?
applied for correction of my date of birth.
when?
It is at K,
19.
page 29, Annexure K. First, I have applied before the managing director, and thereafter by sworn an affidavit.
By
affidavit-
affidavit, you cannot change your date of birth.
Well, thereafter, I have applied before Shevam. That was
When
also
did you apply?
16 October 2013, Annexure 30.
After how many years you have passed the matriculation? You passed matriculation in 1978.
But it is as per service rules. Prior to 3
Service
years.
rule will not govern a matriculation certificate by SEBA. It will be governed by SEBA rules.
Right.
We have held in a number of cases. There is a particular period. Yes, in a given case, your date of birth may be incorrectly reflected or recorded in the SEBA certificate. Therefore, a mechanism is given that within a particular period, you have to apply. If you slip over your rights, that means you know that there is no mistake. You applied in 2013.
Prior to that, I have applied.
Where? Where is that letter? Was it received?
Prior to that, I have applied on 6 September 2013.
Where is the letter?
Yes, my lord, before the managing director.
Where? Managing
Annexure-
director of?
Annexure K, page 20.
Managing director of?
Art page.
How will that help you? If you are contending that your date of birth, which has been incorporated in your service record is incorrect. It is incorporated from your SEBA certificate. So the
But,
origin is,
thereafter I have
origin
applied before.
is to correct the SEBA certificate.
Thereafter I have applied before SEBA.
When?
16/10/2013.
17. So that will not help. Even if you apply in 13,
NHIM.
even if you apply in 13, that also will not help. There is an expression, rest in peace. Not literally, literally, I mean, not that RIP. I think you should rest in peace. Take rest. No need to put efforts in this case.
That proof of
We are not looking into horoscope in today's world. We are not in the 19th, 18th century, 19th century. You are a stenographer. You have a matriculation certificate. There is a date of birth recorded. Even if that is incorrect, you have to apply in time.
I have applied late.
Not a fit case. Okay, let's. The instant writ petition has been filed impugning an order dated 7/3/2017 by which the petitioner, who was appointed as
Lately he was appointed as underqualified stenographer.
who was appointed as a stenographer in the ArtFed was put to impugning an order by which was stated to be attaining the age of superannuation with effect from 31/3/2017. Full stop. It is the case of the petitioner that a wrong date of birth was recorded in her service book as 1/3/1957, whereas the correct date of birth of the petitioner should have been 3/9/1963, correct? In support of her contention, the petitioner has relied upon a horoscope and also what? And also a sworn affidavit. Full stop. Para. While issuing notice, this court by order dated 31/5/2017 had made certain observations which is required to be, which is extracted herein below for the sake of convenience. Eto quote kori bolibo. Second or third. Para. I have heard Sri D. Bora, learned counsel for the petitioner. Full stop. I have also heard Sri K. Kolita, learned counsel for the respondent number 3, namely the managing director, ArtFed, and Sri Roy for respondent number 5.
SEBA.
5, SEBA. The state respondents are represented by Sri. Mr. Totia will be representing? No, state respondents. Handloom textile. And is there any standing counsel? Or any Arbora?
Harvard.
Ardhar. Is he there in the court? Or any? Okay. Sri, please inform Mr. Dhar. Sri Ardhar, learned standing counsel, Handloom and Textile Department, APS for the respond number 1 and 2. Full stop. Para. Sri Bora, the learned counsel for the petitioner, has submitted that the representation for correction of her date of birth was filed on 6/9/2013, which cannot be deemed as being filed, deemed to have been filed in the fag end of her retirement. And therefore, there would be no embargo in consideration of the said representation. Full stop. The learned counsel further submits, on a specific query made by this court regarding the documents relating to her date of birth, relating to the date of birth of the petitioner, Sri Bora, the learned counsel, has submitted that though there is a HSLC certificate of the year 1978 issued by the SEBA, within bracket Board of Secondary Education Assam, the age has been given as 21 years as on the 1st of March 1978. Full stop. On a deduction from the said document, the date of birth comes to 1/3/1957. Full stop. It is submitted that an application to SEBA was also made by the petitioner for correction of the date of birth
On 16/10/13.
on 16/10/2000 to SEBA.
But
Not to SEBA.
Annexure M.
This is not to SEBA. Annexure?
M, page 30.
On 16/10/2013. Full stop. The learned counsel accordingly submits that appropriate directions be issued to correct the date of birth of the petitioner and consequently modify the date of retirement. Full stop. Para. Per contra, Sri Kolita, the learned counsel for the respondent number 3, has raised a preliminary objection that the employer as such, namely Artfed, has not been made a party respondent, and therefore the writ petition itself is not maintainable. Full stop. Para. He otherwise submits that the entire endeavor of the petitioner, attempt of the petitioner, clearly appears to be an afterthought, inasmuch as the matriculation certificate clearly reflects the date of birth of the petitioner as 1/3/1957, which was correctly recorded in the service book. Full stop.
Right after retirement, was returned on 31/8.
He has also pointed out that all throughout the service career, there was no representation for any such correction, and only on 31/3/2000, only on, when was the date?
6 September.
6/9/2013, such an application was made. Full stop. He further points out that the writ petition itself was instituted after the retirement of the petitioner. Full stop. He submits that when the certificate by SEBA was available and the petitioner was in a post which requires certain qualifications, there is no requirement or there is no occasion to even refer to the horoscope full stop. It is further submitted that an affidavit would not change, would not make any difference regarding the date of birth of an individual. Full stop. Para. Sri Roy, learned counsel representing the SEBA, has submitted at the outset that the application stated to have been submitted before the SEBA on 16/10/2013 does not bear any receipt. And the only application found in the record is one dated 15/3/2017. Full stop. He otherwise submits that though there is a mechanism for correction of date of birth in the SEBA certificate in an appropriate case, in a given case, comma, a time limit is fixed. And in the instant case, comma, the application was filed long thereafter without any explanation. Full stop. Para. The issue of employees applying for change of date of birth during at the time when they are nearing the age of superannuation is seen to be a common practice, which is deprecated by the Honorable Supreme Court in a catena of decisions. Full stop. Of course, comma, in a given case, when such application is filed bona fide and within the time prescribed, comma, the matter would require some examination. However, in the instant case, comma, the certificate of SEBA clearly reflects that the date of birth of the petitioner is 1/3/1957. Full stop. The said certificate issued on in the year 1978 was not the contents of the said certificate issued in the year 1978 was not questioned by the petitioner at any point of time, and even if it is assumed that an application was filed as claimed by the petitioner, it was in 2013, which is much beyond the time prescribed for such correction. Full stop. There is no explanation regarding the delay in filing of such application. Full stop. This court has further taken note of the contention of Sri Roy that as per records, comma, the application was filed before the SEBA only in the year 2017, which was the year of retirement of the petitioner. Full stop. Para. This court, on consideration of the facts and circumstances, is of the view that the writ petition does not appear, that the attempt of the petitioner for correction of her date of birth and including the institution of the writ petition does not appear to have been done in a bona fide manner. Full stop. The writ petition accordingly stands dismissed.
Lordship, in my SEBA certificate, there is no record that my date of birth is 1/3/1957. It was their record in the official record.
The
In certificate, it was reflected 21 years.
21 as on 1st of March. So it can be deduced. We have deducted.
But there is no record that my date of birth is 1/3/1957.
So what will be your date of birth as per the SEBA certificate? Tell us if you have done any wrong in calculation.
That was recorded in their.
We are not on the recording. How will you deduce the date of birth from the SEBA certificate?
Well, I am going to tell that it was not recorded that much.
We have not
It was
said,
dated about 21 years.
not about. It's 21 years as on 1st
Dated
of March.
21 years.
We have deduced. Yes. Next.
Item three,
Item 3, to a 17 matter, who is the senior? What is the matter? Madam, what is the matter? Karbi Anglong. What is the matter?
Appoint. Appoint.
Hmm?
Appoint.
When is your
Count-
senior going to come back? Tomorrow? Okay, we'll have it on Friday, 16 matter. It is submitted on behalf of the petitioner. Sir, don't go away. It is submitted on behalf of the petitioner that 3M Sarania, Learned Council, is out of station. Full stop. The respondents are however represented by their Learned Council. Full stop. Para. Considering that this writ petition is of the year 2017, comma, list day after tomorrow for admission hearing. It is 16 leaves. Yeah. 17, how much I said, 17. Okay, day after tomorrow. Okay.
In this case,
Hmm.
it's the promotional method of inspectorship, or section it takes some time, Lordship. I will think that.
17 matter,
I will
Mr.
file that-
Rusami.
file that.
17 matters.
Lordship.
What is the subject matter involved?
In fact, Lordship, in this case, the respondent, without considering the position of the respondent, Lordship, the 33 numbers of another sub-inspector were promoted to the inspect.
Hmm.
Was not taken.
Yes, what is your contention? What do you say?
Lordship, the petitioner was promoted on 6/10/2009, Lordship, as sub-inspector at Kirang
But,
DER.
if there was a delay caused by you in his joining, should he be made to suffer? If there was fault on his part in not joining the promoted post, here first there was no post where he was posted. Then you changed. In the meantime, there was a delay of around 40 days. For that, he should not be made to suffer. You are fighting for a seniority.
Brief expression.
And he's only praying for notional seniority. Why don't you confer?
Any date, Lordship, after vacation, Lordship, I will.
No, after vacation. We'll have it tomorrow. You take instructions. Are there any private respondents, Mr. Bora?
My lord, private, no, my lord,
No,
no,
but Lordship, right? But the of the petition may check the press.
No, it will not make any difference because he is not claiming anything against the private respondents. If he makes out a case that his seniority position needs to be properly reflected in the gradation list, he has a case.
And secondly, my lord, if your lordship peruses annexure 15, similar relief has been granted to another other employees, my lord, when there is delay in joining their new professional. Similar. my
Mr.
lord.
Goswami, the rules are very clear. He is given a particular time, normally 15 days to join. If he doesn't join, he may lose his seniority.
Yes.
But here, he's trying to make out a case that the delay, whatever has occurred, is not because of his fault.
He
There were
went there-
compelling circumstances from the side of the respondents for which.
Yes. The for
On Friday.
Yeah.
Friday, 17 matter, sorry. We're giving you exceptionally to, otherwise we'd have
Monday,
disposed.
Lordship, Monday. Can it be on Monday, Lordship?
Okay, 8th.
Yes.
Third Sri DP Bora, learned counsel for the petitioner. Full stop. Para. Also heard Sri JK Goswami, learned state counsel, who however praised for some time. Full stop. Para. Considering that this writ petition is of the year 2017, comma, this court has reluctantly granted some time to obtain instructions. Full stop. Para. List on 8-4.
Obligation.
6 and 7.
Take up this letter for fine.
There are two matters.
Yes, ma'am.
Same petitioner.
Yes.
Okay. Which matter should we take up first?
So 77.
Now,
16 years the lordship for
Now, which one will take up first?
preparation of the post-
2101.
Yes, ma'am.
Okay, we take up 2101 first.
For regulation
Okay, now
Oh.
tell us the facts.
the petitioner was is working at the LAD or DP office
Working as
at the LAD LDA type. But
DTO office. What is DTO and office?
District
Not DTO and office. It's either DTO or DT office.
Yeah.
LDA come typist. Where is the appointment letter? Where in Kamrup?
Yes. Page 11.
Date
Date is at 8 October.
8/10/2002. Okay. Thereafter, what happened?
Thereafter, your lord was working there, but post was not regularized
You were working in a temporary capacity.
as a on a leave vacancy.
Leave vacancy.
Yeah.
Let us see page 11. Purely temporary, not entitled to any regularization. And then the following have been temporary leave vacancies. Can see. No. Okay.
Thereafter, he was working there, but his job was not regularized. Then this petition was filed. Thereafter, in the year 2017, they stopped paying her salary.
April 2017. Okay. Thereafter, what happened?
Then accordingly, this second,
Where are you working?
yes,
In 2017, in spite of working, your salaries were not paid.
yes.
Where have you stated in your second petition?
Yes.
Where have you stated? Where are your pleadings?
Page 31, annexure 10,
Of which petition?
second, this petition 3845 of the
No, where are your pleadings? Regarding that you are working.
page 9, the second
Page 9, paragraph.
paragraph.
Please read.
Pendency of the petition or for certain the salary for the petition stopped by the not received from the month of April 2007. It is mentioned here that the petitioner is regularly attending, though her salary was unpaid, but in 2017, when the petitioner went to attend in the office of the but the petitioner was not allowed to sign the attending register as per the direction. But on being asked by the petitioner, disclosed that as the petitioner has not received salary, she is not allowed by the service. Being dissatisfied with the reply, the petitioner asked to serve copy of the order. The respondent did not serve any order with regard to joining a service. The petitioner has submitted representation before the additional chief secretary of the government that Department of 117 for not saying. As for the last order, your lordship were directed to make the partial. The next day, the last
Which order?
19
In the first case? 19? 19/1, 2000? 24.
it's
19/1. In which case? 2101.
they have filed an IA. I have subject before this honorable court, not before the salary for the year 2017 as yet because of the online procedure regarding the salary introduced for the year 2017. So we have written to the finance department since working in a few decades on the strength of the interim order passed by the honorable court. They have please and I will.
Now, where is that order where finance department has been directed to be made a party respondent? In the IA?
There is no direction, but they have filed IA.
I-
IA has been allowed.
Okay, you have filed IA?
Yes,
That was allowed
allowed.
for imprisonment. IA civil. One 752 21 minus department completed. Okay. On 19/1. 19/1/24.
Yes.
Okay. Is there any interim order?
Perfect. Perfect.
We'll come to you. Is there any interim order? Directing, directing that you should be allowed to
Yes, yes,
continue.
yes, yes.
Which
At
one?
which the plot of the 2017 study passed by where your lordship stated that still did the post is paid filled up regular basis.
No, which
The-
order? Order dated?
Order dated, your lordship, she has filed on another repetition in the year 2002, your lordship, where her post was dismissed, your lordship. Then at 2002, a repetition was filed. it is a
No, in these
26
proceedings, is there any interim order?
in this proceeding, there is speech report. But the earlier proceeding, my lord, may kindly have a
Earlier
look.
proceedings was the 2002, that circumstances have changed.
Till the fill up of the regular equipment, we continue. So this, still this continue, so lord, may kindly observe. So,
No,
Your-
in the,
in pursuant to
in
that-
paragraph 22, which was just read out,
Yes.
it has been stated that she was not allowed to serve on of after a particular date. Then after that, how is she continuing? Are you continuing or not?
Yes, I continue.
Without salary?
Yes. That-
What capacity?
Your lord,
The posts have been regularly filled up. Your initial appointment was in a leave vacancy. It was temporary, and there is a specific clause that you will not be entitled to any regularization. You have accepted that.
Your lord, I have been working there since 2002 years.
Can you enter into the service by the back door?
So,
Why don't you face a recruitment process? What
But-
process did you face in getting the job?
so, your lord, I was appointed a leave vacancy.
That is, the leave vacancies after fill up of the leave, when the incumbent joins back, matter ends there.
But they have made any advertisement regarding that.
So can you
So, because
continue?
because
Can
of
you
the
enter into a
appointment,
public post without any facing any recruitment process by leaving the hundreds and thousands of other incumbents?
Yes.
What right do you have that you'll be selected from the thousands and thousands without any recruitment process? We talk about transparency, fairness. Where is the transparency in your appointment? Where is the fairness to the society? Thousands of qualified, if not more qualified than you are there. They are not entitled to this post, at least for consideration. You have entered through the back door. You go out of the back door. Matter ends there. Where is your right? Serving, that is something, it's by the grace of the employer. Your serving itself is questionable. Your entry into the service is not in accordance with law.
they paid the certificate.
That is okay. You are serving, you have paid.
That-
17, you have made a statement in 17 that you are not allowed to serve. These are not cases where we'll grant any relief. Sorry.
Thank-
For?
Tomorrow, your lord.
Sorry, after hearing, you are asking for
Yes.
time.
Your lord, thank you.
Whoever will appear, we are not going to adjourn after hearing a matter.
Right.
Don't ask for a date of 2016 matter, that too after
Yes.
hearing.
Tomorrow, your lord, kindly,
Sorry,
kindly tomorrow. Because your lord, I can,
what is your name?
yes,
We have refused your prayer. Madam, please don't embarrass us. We don't like to repeat what we have said. What is your name?
yes,
S?
yes.
Heard. Miss S. Nazdin, learned counsel for the petitioner. Also heard. MS. MD Bora, learned standing counsel, transport department. As well as Sri P. Nayak, learned standing counsels, finance department. Full stop.
Yes.
Para.
Your lord, judge, your lord. Umadev and others. When it was said that
Continued. In paragraph 53, you read what is paragraph 53 of Umar Devi? Do you meet the three conditions? That you have entered into the service by following the due process of law. You have continued without any interim order. You possess the qualification, nothing. Don't cite Umar Devi like this. It will go against you. Read paragraph 53. The petitioner was appointed Wide an order dated 8/10/2002 as an LDA cum typist in the District Transport Office, Kamrup. Full stop. The petitioner claims to have continued in the services, and in the year 2016, the first writ petition WPC 2101 was instituted seeking regularization of service. Full stop. During the pendency of the said writ petition, the salaries were stopped, for which the second writ petition has been instituted on instituted in the year 2017, being WPC 3845 of 2017. Full stop. Para. The learned counsel for the petitioner has submitted that the petitioner having been allowed to continue in her service for a long period of time is entitled for regularization of her services. Full stop. It is also content by drawing the attention of this court to the averments made in paragraph 22 of the second writ petition, it has been contended that the petitioner was not allowed to sign the attendance register and accordingly not allowed to serve. Full stop. Para. Subsequently, IS Civil 1752 of 2021 was filed for implement of the Finance Department, which was accordingly done by order dated 19/1/2024. Full stop. Para. The learned counsel has submitted that the petitioner having continued in service since the date of her appointment in the year 2002, appropriate directions may be issued for allowing the petitioner to continue in her service and also to regularize her service. Full stop. The learned counsel has relied upon the case of Uma Devi versus so-and-so, reported in so-and-so. Full stop. Para. Per contra, Ms. Bora, the learned standing counsel, Transport Department, has submitted that the initial entry of the petitioner in service was not in accordance with law and was only of a very temporary nature in a leave vacancy. Full stop. It is submitted that so far as the period of service rendered, the salaries of the petitioner have been paid, and therefore no relief whatsoever is entitled to by the petitioner. Full stop. Sri Nayak, the learned standing counsel, Finance Department, while endorsing the submission of the Transport Department, has submitted that unless the entry into the services is by a properly held recruitment process, no claim would be maintainable. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. A bare look at the appointment order dated 8/10/2002 would reveal the following aspects. Number one, The appointment was against a leave vacancy. Number two, the appointment was purely temporary and was to be terminated at any time without assigning any reasons. Number three, the appointment shall not entitle any right for regularization. Full stop. Para. The petitioner having chosen the said appointment without any objection had chosen without any objection. Full stop. It is another aspect that the petitioner was allowed to continue till the year 2017. Full stop. However, by mere continuation, comma, the aspect of regularization of the service of the petitioner as claimed cannot be considered in view of the clear stipulation made by the Honorable Supreme Court in a catena of judgments, including the case of Uma Devi, which has been placed on record. Full stop. The entry of the petitioner in the service does not appear to have been done by following the due process of law. Full stop. In any case, comma, the appointment was a very temporary one against a leave vacancy. And only by the fact that the service of the petitioner was extended from time to time will not grant any kind of right to the petitioner to seek regularization or further continuation in service. Full stop. After all, it is the prerogative of the employer as to how and whether to continue the service of a temporary employee. Full stop. Further, comma, the entire concept of ad hocism and temporary appointment is liable to give way to a properly held recruitment process by following the due process of law, whereby all eligible candidates are to be given a fair opportunity. Full stop. Para. In view of the aforesaid facts and circumstances and the discussions made, both the writ petitions are dismissed.
And to develop
Yes.
Item 1, timing.
Social welfare. Madam, you are there? Social, yes. What is this?
Well, here that whether in a given treatment process, where there is specific stipulation, the notification or tweet that service for the physically disabled category will be granted as per law while filling up 20. And accordingly, applications were made. 30 can decline to make any selection or appoint anyone from that. So, I was one of the applicants for the post of
Supervisor in the social welfare department. Okay, there was a recruitment process.
recruitment process was in 2014.
2014. What is the date? There's an advertisement.
24 to 2014.
24
People will find it at page
to 2014.
24 to 2014.
Yes.
Page 22, Lord.
Page 22.
Yes. 23 is the relevant part. Vacancy position or tip at the top of the
Hmm.
place of joining Indian ICTS project. Supervisor temporary on regular basis. For a vacancies 20 number, 22 job profile, qualified graduate, discipline art. Then reservation down below, madam. For SC, STP, SCH, OBC, MOPC category candidate as per statutory program made by government, including reservation for persons with disability as per existing norm. Candidate must enclose the copy of caste certificate and copy disability certificate for disabled person. Where so the
Okay.
so 24 that I did under the 1996 act. Sorry, 95.
Hmm.
It was under 1995. So that time 3%. 3%. 3%.
3% is,
3% reservation, 20 posts, up to 1%. Now, ultimately, they didn't select anyone. And it is the admitted position that there was no selection made in the category of PWD. And hence, no one got it. I said that, well, I was one of the candidates, I should have been considered against that. I am having all other points. That's fine. Now, during the course of this proceeding, this Honorable Court directed have to make it clear because this is reservation is not vacancy, but because not of the strength, the cadre strength. But this Honorable Court wanted that to disclose all these things who were selected, whether you considered at all. Records were asked to be brought. Honorable Court granted us, but to accept records. By order dated 18/10/2023, this Honorable Court directed that we brought. Now we filed an affidavit after considering the record. So examining the record, we brought it on record. What was there on record? What proof? That affidavit was kindly. 105 page 105. Yes.
105.
Yes, our affidavit.
Yes.
Starts at page 106.
Yes.
Alert will kindly come to page 108.
108. Yes, please.
Better let us read from page 107 so that a lot of people get the answer. From paragraph 2, I will please. That in pursuance of the order dated 18/10/23 passed by the court, the counsel of the petitioner perused the CD containing the details of all the candidates, including the candidates who had appeared in the selection process.
You can leave this part.
Yes. Then in the list, paragraph 3.
3, yes.
In the list of registered candidates, total 56 differently able candidates' names have been enlisted. But out of the said 56 differently able candidates, the authority concerned should admit cards only to 7 candidates, which has been reflected in the admit card data. Out of the said 7 differently able candidates, only 2 candidates applied for the post of supervisor regular, which has been also categorically mentioned in the admit card data. In the said admit card data, nothing has been indicated against the name of the above 7 candidates that they are belong to differently able reserved category. In column D of the admit card data, the list of candidates who appeared in the written examination, only SC, OBC, and unreserved category has been mentioned against the name of them. So, the 7 candidates they listed, all were shown in the caste reservation, not as PWD, specially. That in the list of written appeared candidates, only 5 candidates' name has been enlisted, and they had not been considered as differently able category. In that category, none was considered, that is the admitted. That moreover, the stage 4 Excel file of the city has not contained the final selection of candidates and list of or column in respect of doing marks obtained by the candidate. Besides that, no any resolution proposal adopted by the authority department respect of cut-off marks has been found in this file. That after perusal of the city, it has been found that 7 differently able persons named from the list of registered candidates has been assisted in the admit card data, and their name and type of disabilities are as below, as per the said admit card data. Govinda Das, post then with the cooperative
This you
There-
can, this details you can skip,
7. This 7. Sorry, my lord.
details you can skip, the
Yes.
names, etc.
According to the Act of 1995, only 2 persons mentioned above, namely Deepa Khatun and Kunda Upadhyaya, are eligible to get the reservation under different category. The authorities concerned has assisted the names of Govinda Das and Pataka as the book and other 5 pages has been moved to the data as unreserved candidate. So they were considered in the open category and 2 were in the STN. It is-
Mr. Mohanto,
Hello.
the concept of reservation of the instant nature, these are reservation which will cut across everything.
Yes.
It can be open category, it can be SC, it can be
Yes.
ST. Just like a woman candidate.
Yes, special reservation horizon.
Horizontal.
But
It's
They will
all,
fit in.
yes, they'll fit in. Now, a person may be in the general category, he may
Yeah.
be, now we are concerned whether the 2%, 3% which comes to 2 of the posts have been filled up
No.
with persons having this particular reservation.
Nothing. Not at all considered. Nobody was considered, nobody was appointed, nobody was selected. That is it not an illegal?
Now, is it your case that cutting across the vertical reservation, none of the candidates belonging to any of the vertically reserved category, including open category, also belonging to PWD category have been appointment? Is that your case?
Yes.
Yes.
PWD category, none.
Yes, madam.
They say only on caste basis. That is
No,
it.
what they have said and what government council may say may differ, because belonging to a particular caste or may open category may still, one may still belong to the PWD category.
That's not as PWD, not as the caste, not caste. To the double reserve. But court also said by that is the double reserve. You cannot. Only one reservation. One.
Yes, we'll come back to you. Just, madam, what is your stand?
The number of posts that was addressed
20,
also it's 20.
yes.
So we have a
Now, senior council has rightly pointed out 3% would come to 2 posts, not more than that.
thoughts. But we have
Not 2 posts.
What?
1 post. 1 post.
out of 20 lots.
Is it 1 post? No,
No, it's not one.
it's not 1 post. Mr. Mohanta, will it be 1 post?
I confused one post. That will be one
Lot,
post.
point something lots.
Point how much?
More than 0.5 it comes.
And that is your point how much?
20 post, 3%.
For 100, it will be 3 lots.
3%. 0.6.
If it is 30,
Zero
then
point-
1 lot.
0.6. 0.6 you can have it round off to 1.
1. Rounded off to 1.
0.6.
That is why I said 1.
What is your stand? Did you appoint any person
No
under
lot.
this?
Lordship.
Why?
Because as per data lordship, their number of posts that are picked up lordship. Since 2005, we have the data lordship.
Yes.
2005 lordship, there was advertised post was 2012, and basically handicapped was 6 that has been appointed lordship. 13 also 24 and 19 appointed lords. In 2014, advertised the year was 2016 lords. There was 24 that were lords, but
Yes.
that no number of really handicapped was that is qualified lords, and no one was appointed that particular year. And subsequently also that as per the reservation, the person will is being appointed. This is there. The affidavit lordship, we have said it in page 46 lordship.
4-6.
Yes, 46. That is the first affidavit that we filed. But
Yes. Yes.
lordship, in that paragraph, we have said that lords. And so for the post of supervisor under the Directorate of Social Welfare, as which was advertised by the Director of Social Welfare, had so and so, and accordingly written examination for the said post was held so and so, followed by a vacancy on so and so, and final result of such candidates were declared by the state selection committee on 7 February 20. As per the records available, the petitioner was not selected for the said post. He should be selected on physical handicap category, reserve category. In this regard, it should be mentioned here that as per 100-point roster, 3% reservation that is formed for a post candidate to fill up under the provision of the person with disability. Equal opportunities, protection of rights and participation act so and so out of 100 numbers of posts per category. But the Director of Social Welfare Assam published advertisement only 20 numbers of posts. The reservation under person reserve category does not arise against 20 number of posts as per the reservation policy of the state government. While recruiting the personnel, due regard has been given to the reservation policy of the government.
Is
It
this
has-
correct? Is this interpretation correct?
Lordship, the first,
What is your cadre strength of supervisors? See, ultimately, it will boil down to the cadre strength. See, if vacancies
yes,
at
sir.
one point of time, let us assume that vacancies arising is 10 every time. So there
Yes,
will be
sir.
no occasion to even consider 3% because there will not even be one less
Yes,
than
sir.
0.5. That will not mean that this entire concept can be made redundant. So it has to be considered from the point of view of the cadre strength.
Cadre strength.
What is the cadre strength of supervisor?
X
Yes, Lordship, cadre strength, we have
Lord,
post of
have-
supervisor.
marked as X
X.
required. Pursuant to an order of this honorable court, they have given this letter, which was marked as X. They have shown how many vacancies are still there.
80 lords. 1294 regular and 986 contractual lords.
No, we are not on contractual or regular. What is the cadre strength?
Yes, the cadre strength of the post of supervisor total is 280 lords. Regular is 129.
1294.
Yes, lords.
If it is the cadre strength is 1294,
Yes, sir.
then 3% would be many. You have only appointed 6 numbers.
Only 6 of. That is,
Madam, your approach may not be a correct approach. Even if we leave aside the aspect of total numbers of 2280 and we hold the regular to be 1294, correct?
Lordship, there is one, in the said,
Oh, just a minute. At least 38 posts you have to fill.
I find that are still according. are still
38 posts at least you need to have under this category. Whether they otherwise belong to SC, ST or open category, that's a
Yes.
different aspect. But 38 out of a cadastre strength of 1294, 3% will be around 38.8 to around 39.
Yeah.
39. So 39 you have just on your own admission, you have said that you have filled up only 6 posts.
no, 6 posts in 2005 Lords.
Now,
Then
total physically
2015
handicapped person
subsequent-
no. Total physically handicapped supervisors appointed till the date of advertisement in regular post is 6 numbers.
Then
That
Lord,
is what we understand. If you say something else, then you have to, this is what is a plain reading of, plain meaning of the reading.
Lordship, the advertisement 2015 that was filled up, Lordship, it's of advertisement of 2013 Lords. 19 posts,
This 20 post is pursuant to an advertisement of 2014, 24 to 2014.
yes, Lords. But the persons that were appointed out of 623 Lordship, 19 were appointed on PH category Lord. This is of advertisement of 2013 Lord.
Now, if you are reading the document which has been placed before this court, 27.4, are you having the document? 27.4/2020. By the district child protection officer to the director. Please read.
Yes, Lord. The total strength of the post of supervisor is 280.
Regular
And
is 1294.
1294 is the regular and contractual is
So
980.
let us take 1294,
Yes,
very,
sir.
very conservative number. Let us leave aside the contractual,
Yeah.
otherwise the
Total
numbers will
physically
show.
handicapped supervisors appointed till the time of advertisement dated 24/2014. Supervisor in regular 6 number and supervisor in contractual is 19 number of posts. Lord.
Mm. So this 6, there is a scope to fill up under this category up to 39 posts. So till this recruitment drive, you had only 6 numbers of posts which have been filled up by this category.
Lord.
So there are at least 33 posts which you have to make an endeavor to fill up if there are candidates.
Lordship. The subsequently, Lordship, this was then 2019 also recruitment drive were picked up and 2018-19 also 21.
No, see, this is a communication of 2020.
Put one.
No, we have got the cadre strength, madam,
Let us check. Yes, sir.
which will not change. This is 1294 regular.
One thing that's have second copy, but Lordship may kindly bear.
Doesn't matter. Contractual post. This was a regular appointment process, regular recruitment or contractual?
It's
This was
a
for regular.
regular.
Regular. So this data is only meant for contractual, madam. This will not help you. See, out of the, let us read this again. Total strength of supervisor is 2280, out of which 1294 regular,
Yeah.
986 contractual. Contractual posts 986 were created in 2007, 8 and 9. Out of 986 contractual posts, 623 posts were earmarked for general category, rest were for BTC, KAC and Dimasa. Now, 623 is for general area. Now, in the recruitment drive, this is for contractual. You have said that in 2005, 212 posts were filled up, out of which 6 posts were filled up under PH category.
Yes.
2005 will be under the regular selection because you have created the contractual only in the year 2007 onwards. So 6 posts. 2015, 19 posts.
15 they fill up.
This
19
is out of
posts.
623, this contractual
Yes,
appointment.
contractual. They have given the list.
Madam, I think this, you are referring to the reservation, these are in the contractual appointments.
Contractual. They are page 66 lordship. They have
You-
given
Main
that
thing
list.
is lordship, all the recruitment process of that year has already been, it was his lordship and it is there with the investigating authority lord. So we are facing a little difficulty lordship of collecting all these
No.
things.
See,
That is why
if you have filled up the post subsequently, that will not take away the rights of the petitioner who is seeking a consideration with regard to the period when she had applied for the, or when you had held the recruitment drive. If you have deprived her in 2016, you cannot say that 19 we have taken care of this category. She is fighting for her rights.
But one more thing, just only that whether she has applied for this, because subsequently there was an application to consider her for the PH category lord. This is there in the read petition.
Where is your application, Mr. Mohanto?
that by well, the first application was sent by post. That is not with
You have the copy.
Lordship, we don't have the copy, but subsequently, Lordship,
But
the
I-
annexer 5 that has been written, Lord,
Of
this is at page 30 lordship.
Page-
page 31,
Page 30.
the particular version that I,
Yes, the
Referring
English
lord.
translation at page 30. That's the part.
31.
Vernacular is 30.
so it creates a
Please,
doubt,
please,
Lordship.
please read. অসম চৰকাৰ সমাজ বিষয় চিৰিজ প্ৰদান অধীনৰ বিনীত নিবেদন এই যে issued.
পদত সকলৰ বাবে অধিনীয় প্ৰাৰ্থীত্ব আগবঢ়াইছো have already applied. It was only
No,
subsequently
Lordship,
written.
that অনুসাৰে জানিব পাৰিছো
পাৰিছো
যে
মহোদয়,
সমাজ
সমাজ
কল্যাণ
কল্যাণ
বিভাগৰ
বিভাগৰ
ICS চুপাৰভাইজাৰ পদত সকলৰ বাবে আবেদন বিচাৰিছে। উক্ত পদত সকলৰ বাবে প্ৰাৰ্থিত্ব আগবঢ়াইছে। দেন মহোদয়, গতিকে অতিৰে জনাব বিচাৰিছো যে অধিনায়ক এগৰাকী শাৰীৰিকভাৱে অক্ষম আৰু উচ্চ শিক্ষা এগৰাকী নিবনুৱা যুৱতী। So what's the point of writing it later on, Lord?
গতিকে দয়ালু মহোদয়
This is
দুয়ৰ
That what is
this is the subsequent thought, Lord.
they could have known it. There was this argument, for the sake of argument, one can raise it. Why was it necessary of submitting subsequent application? But this can always be done a harder way. Because last date was on 31st March 2024. It was on 18/14. I submitted this saying that I have already applied for. I have opted for. I have done my candidates. I request you to consider, because I am also a physically handicapped person. I have applied in that category. I applied like a special prayer for it act, and it will not in any way that affect my candidacy.
Lordship, if the petitioner has not applied for that particular post and subsequently seeking on that lot. So that's justified lordship. Particular. And the disability certificate that they have is of 2005, which is valid for 3 years.
Page,
Page 18,
It got
page
it's of
18.
2005. So subsequent, this thing has not been addressed. Lordship.
the certificate I submitted.
Of 2005,
Yeah.
and the valid 3 years.
That validity, of course, it is extended now. It has been extended for life. Of late,
Where is it?
it was not done every year.
No,
I
where is
have
it?
submitted page 114, or people find. I have submitted it. It has been extended later with a unique disability ID. Relying on my this certificate.
For that's
40%,
Page,
page 114.
114.
and the same the lordship.
My concern is that this certificate seems to have been extended continuing. Because this is renewed. Though later on, but it continued. Well, with retrospect. Not a phrase that I have
111.
114.
114.
Right. So, David, I have said it, but this was not the ground on which they reject. Is not with but the department. But they don't of it.
No, that one question will arise, though the issue which you are trying to raise is a very serious and important issue. See, you have a certificate of the year 2005 at page 18,
Yeah.
which is admittedly for 3 years.
Yeah.
Now, this unique ID is of the year 2020.
Right.
That too after filing of the writ petition, which was in the
True.
year 2016.
True.
Do you have any document to show that at the time of,
No. To my instruction, there was nothing.
because why we are asking this question, Mr. Mahanta, is that in the, we had just happened to have the grants with your admit card at page 32. Page 32.
Yeah. Yeah.
Page 32, there is no reference of this category. We
Well,
have been
That is why.
stated to be OBC.
That is why my assumption was they have shown these candidates, all these candidates in caste wise basis, not as PWD.
No, we'll only examine your case.
They have not, they have not shown anybody or selected anybody under PWD. They have shown all the caste reservation against caste, particular caste, not as PWD.
No,
So
see,
I was also accordingly shown
see,
against
we
my
are
car.
examining only your case. This is not for the general
That's true, my
consideration.
lord. But then how they have considered the cases of this category of people, that in that case, Lord People Five, none was considered. Me
No,
also was considered only against.
See, you have espoused your cause. You have not been able to show any document or any other materials that with your application, there was any documents annexed to show that or to claim that you belong to a particular category of PH.
Yet I have accepted that category, my lord, that which says that it deemed only for
It is
That-
for
that-
3 years.
there was period 3 years that was mentioned, but that was continued otherwise. There
No,
was
no,
no renewal that time.
No, no, where is the document to show that it was continued?
Well, there is nothing of that sort. Only it was renewed in 2020.
Have you stated anywhere that it was continued?
Yes, my lord, I have just made a statement because there was no such any exercise undertaken by the authorities that time. I could prevail. But you may kindly
We have read your
at
averment in
110,
paragraph
my
2.
lord, at 110. That's
At
why,
paragraph 2 of your writ petition, page 5.
that is in the read petition, but subsequently regarding that renewal, 1110 page Lord People can. Because I cannot improve on that line, because what was there, I submitted it, and there was
110, yes,
paragraph 9,
yes.
110 page. Deponent respectfully states that the deponent several times approached the concerned issuing authority of her disablement certificate dated 655, sector 1 of it. That is its 6 social welfare 1. As the state authority informed its court that no critical board was constituted, it is authority for renewal of the disablement certificate.
See, you have verified this paragraph as per records. You have visited the office. Will it be a part of record?
No, there's knowledge.
Unfortunately, verification is as per
1
record.
to 8. 1 to 8, knowledge
This is paragraph 9.
9. Good, good.
Writ petitions, we go by
Yeah.
pleadings, as you know.
Definitely,
Verification of pleadings is most important, sacrosanct.
definitely. It cannot be recorded.
If at first you have not made a statement in the writ petition, we may go to the extent that even a rejoinder affidavit pleadings, it can be constituted to be pleadings. But your verification is as per records. Records means there has to be some document or materials from which you are having this knowledge. Otherwise, we
But
thought,
probably that is here also the state renewal certificate is placed in that paragraph itself, that's why it has been shown as record. But the fact remains that that renewal was granted 2020 and after filing of the state petition, because when it was not done that time, there was no statement made in it. There cannot be. Only in the rejoinder that
no,
that point was made.
no, rejoinder, you are free to make pleadings in the form of rejoinder. But the fact remains that from after expiry of 3 years, from 2005 till the filing of the writ petition, there was no documents to substantiate that you belong to a
That could have
particular
been.
category.
That-
And these are claims. These claims have to be based on particular documents which are issued by the competent authority. Maybe for PWD, maybe for SC, maybe for ST. There are many, in fact, there may be allegations of fraud use or fake use. So the necessity is that the appropriate authority, competent authority should have issued a certificate. You may have a case that it was not renewed or there was no competent authority constituted to have another medical board. But you have not said anything in the writ
That
petition.
was not. That was. The writ petition-
Issue is no doubt of very important nature, but at the instance of this present petition, whether we can
True,
go
but
into.
at least they said 40 mayor is considered one. It that.
No, the question of
Otherwise,
rejection,
otherwise I could
the
have.
question of rejection would not come unless you say that they have considered you as a PH and then rejected. They have considered you as an OBC.
Yes, That is why I say I should have been considered in that category, that could have rejected me there.
See, the first application is not there. From where we could have seen that or found that you claim to belong to PH category. There is a subsequent application. No doubt it is within the last date, before the last date of the, but that is also not, there is no document to show that as on that date of filing, you had a valid certificate.
That going by the narration city certificate, it shows that this was validity was for T. But it's not the case of the authorities at that time. These such certificates were not relied on. And because there was the process of renewal, there was no renewal done. Then of course I would have to consider this also. They have not taken that. Now only because they have raised this point. The authorities, they have never raised. It was not done at all. And subsequently renewed. That renewal is for your. Renewal is always, when it is renewed, it is retrospect. Fact should be given.
My humble submission point was raised, Lordship, and that's why the additional evidence been
Yes,
filed.
here it was.
That is stating these things, Lordship.
Here, but the gist of argument was there, but not by the authority. In their affidavit, first 1, 2, 30%. They have submitted 2 affidavits, 6 raised. There are 2 affidavits are cited. But if I kindly go to that page 46, I will point out there are 2 affidavits. What is contradictory?
46. Yes.
Paragraph 4, line about
We-
9.
We have read this.
As per records available,
Hmm.
kindly
We have
Well,
read this.
once more, kindly,
Yes,
as per
please.
records available, the petitioner was not selected for the said. Petitioner claimed that as the long handicap category, this is selected on is regard to by 100% roster they have given.
This interpretation may not be correct.
Here, kindly come
You-
to
you-
now, kindly come to second affidavit 62 page.
46.
62.
Just a minute. $62.
61, their affidavit starts. This is why response number 2.
Hmm.
Director, Skill Welfare. Page 62, Lordship will find. Paragraph 3. That the selection process held period represent 24 to 14. And the petitioner and no other candidate as physically handicapped category was participated for the process, as reported by E. Grab.
Yes, that is
Yes, sir.
I thought,
Just a
Let's
minute,
say
just a minute.
neither me nor any other else. Any other. So therefore, they never considered physically handicapped category. Therefore, they never rejected not their case. All throughout that you were not qualified because your uh, certificate was fake. Not there. They initially said I never participated, then said nobody was considered or feared.
Anything else?
That reports also they said their consistency, nobody, no candidate was there, nobody was considered. Nobody was admitted in PWP. But from the record kept this the affidavit 108.
After inspection of the record.
Provisional
Yes,
record.
that
We have brought in, it appears at least that there were 1, 2, 3, 4, 5, 6, 7 candidates or so as PW, but they were again adjusted, considered not as PW, but they are considered as not. Therefore, uh, the authority has violated process. There were post line. They ought to have considered. They ought to have considered me. They never rejected me on that ground that my certificate was valid on that day. I participated. They could not show any records. There were anomalies, not many. They say court allowed them to approach the authorities to get those certified copies with the order of this honorable court. They did it and brought record. Then this honorable court allowed us to produce those records and then bring it on record. Therefore, it shows that there was no on. I'm entitled to be considered and appointed in that category because it is the court has the time and again said it is special law. You cannot ignore. You will have to make an appropriate provision for them. Supreme Court decision. I'll just place it back. Yeah. Vikas Kumar versus 2021 5 SCC 370. Reasonable accommodation for them past feature. What about paragraph 44 Lord Chief Justice.
44.
Four. The principle of reasonable accommodation captures the positive obligation of the state and private parties to provide additional support to persons they effective party. The concept of reasonable accommodation is close in age below. For the present, suffice to say that for a person with disability, it is constitutionally granted fundamental rights to equality, freedom, the right to life, the Article 21 thing follow if they are not given this additional support that helps make this right real and meaningful for them. Reasonable accommodation is the instrumental or an obligation of society to enable the able to enjoy the constitutional guarantee equality and non. This context should be posed to remember R.M. Lodha says there was observation Sunanda Bhandari's of the court in the matters of providing relief to those who are differently able. The approach and attitude of the executive must be liberal and relief oriented and not obstructive or backward. Therefore, I will request this honorable court to consider it client. And another decision of this honorable court, not a similar situation when there was no consideration, this court directed collateral bench that the petitioner, who was the only candidate before this honorable court, should be considered an appointment. See that this is the 2022.
Saidur Rahman.
Yes, Saidur. Saidur Rahman. According to the apex court decision, if I may take your lordship from paragraph 9. From paragraph 9. I have considered this substance done to counsel so and so. There is no wrinkle at the bar that as many as 4 posts of veterinary officers, block veterinary officers were reserved for being filled up by candidates belonging to PFW. However, as per the advisement, these 4 posts were made only for candidates. Therefore, the core that arises for is as to whether the respondents were justified in further reserving those 4 posts mean for PW candidates to be held up to be filled up only by candidates belonging to the above specification. From the advertisement, it's clear that the recruitment was a special drive for intake of only reserved category candidates belonging to the above for general candidates as well. As a matter of fact, out of the 113 posts as per as many as 16 posts were for general category candidates. Also, no doubt about the fact that the person in fact suffers from disability, being a person suffering from their handicap. As such, you would be entitled to benefit of exemption for disability. It is also the admitted position that out of the 110 candidates who appear in selected the 1 candidate, namely so and so was selected against PWD belongs to the OBC category, but no other candidate was selected against it. Remaining 3 vacancies under PW category, representing the fact that was one of the in the case of Mahesh Gupta, referred by the learned counsel, but Supreme Court has categorically held that a disabled is a disabled, and therefore the question of further reservation on the basis of caste, creed, and religion would not ordinarily arise. Thus, the view has been expressed by observing that disabled are by themselves a special class, and to that extent their further classification cannot justify. Similarly, the view expressed in the case of M. Salva Kumar and others, wherein it has been observed that physically handicapped category is a category in itself, and the person for physically handicapped have to be treated alike in extending the concession regarding regardless of the facts whether they belong to a general category or category. Applying the ratio laid down in the case of Mahesh Gupta and Salva Kumar, this court is of the unhesitant opinion that having reserved 4 vacancies filled up by PW candidates and having the recruitment process, there was no scope for the court to further reserve those 4 vacancies in PW category to be filled up by only by candidates belonging to OBC above. Having held as above, is to be noted here that out of the 4 vacancies reserved for PWD, as many as 3 vacancies not be filled up since no candidate belong PWD category comes from Bhupati among candidates was available. It was on such count that no name could be recommended by the APSC for filling up the remaining 3 vacancies. If that is so, it is evident that even if the petitioner was recommended as PWD candidate against one of these candidates, even then, the same would not cause prejudice to any candidate belonging to the above SPA. The learned partial counsel also did not offer reasons as to why such a course not have been adopted by the particular authorities in case of. Similar is the case here. It is also to be borne in mind that India is a signatory to Beijing.
That we have read.
Yes.
Beijing Convention.
Yes, Beijing. That declaration is there on 17th. Down below. From the above, it is clear that the government not only have a statutory obligation to identify posts which can be reserved for persons with disability, but would also have to earmark substances not less than 3% for filled up only by persons with disability. Thus, mandate of the statute is the horse in sub-classification, and over and above any reservation based on caste, creed, and religion. Therefore, viewed from that angle also, respondents not have used to consider the candidate as a candidate belonging to the PW category in one of the vacant reserved for PW candidate, more particularly when there was no other contender for those posts. For the reasons stated here and above, order dated so issued by the law for that side. So respondent was directed to cause the petition, consider the case of the petitioner for
Yes.
appointment in the post of.
Yes.
Therefore, my response same Carol, they never considered my case. Man was considered, but I have a right to be considered. I am otherwise qualified. I am a disabled person. I am disabled for all the time from 2020. To take note of that. That I am continuing to suffer, and I will remain as suffering as PW candidate, because therefore, my responsibility directly output. Consider an appointment. This one post available, that was selected. I am put. That is my.
Yes, madam.
And there are lot many vacancies of they have not filled up. 33 at that time it's only in 15 they have filled up that 19 temporary vacancies. 19 temporary cadre they have filled up by PW. Regular, none. That
Yes, madam. CD means?
But they have examined by the,
Of the documents.
yes.
Then we have the
There
documents
and lordship one more, and again refer to the page 31 lordship
of,
of the writ petition.
okay.
Their lordship, if we correctly that understand the application that submitted by the petitioner lordship, it was never asked because she already have forwarded her candidature by filing a proper by submitting a proper application. Lordship. Later on, this has been filed, but here nowhere this has been asked that her candidature be considered on that category because the line itself read lordship. Because they also have stated this thing in the writ petition. And that মহোদয় প্রতিষ্ঠানে জনাব বিচারপতি এগৰাকী শাৰীৰিকভাৱে অক্ষম আৰু এগৰাকী জীৱনমান যুৱতী গতিকে দয়ালু মহোদয় দয়াৰ চাই আপুনি খালি থকা ICS supervisor পদত but they have not asked that their candidature should be taken on that age category. This was never been asked, and the subsequent part of the petition, where because he came out successful unsuccessful, and then she filed one RTI. Thereafter, she has stated all these things.
No,
And
no, this application was filed before the
Yes.
last date.
yes, I am not onto that.
Okay.
I am not on that. I am just stating here in this application also.
Okay,
She has not
we
directly
have
asked,
understood.
for consideration of her case on PH category.
That we have said.
Because, my lord, my
Though
answer
there
is,
is a mention, but the claim is not on that particular category. That is just
Yes,
submission.
Lord.
my lord, my response to
subsequently-
that application is already there in that category. I only made an additional prayer, please consider. That is additional prayer made before you.
Okay.
That I have already applied, please consider, keep some thought on that. I need certain compassion.
Do you have the application form which was submitted by the petitioner or the intending candidates? We are more interested in the petitioner's application, initial application.
Yes,
Do you have it? Do you have it?
Lord, that don't have because all of the Lord. They provided all this for- and that I did not, that's
Investigation by whom? Vigilance Department.
Yes,
vigilance department.
therefore this honorable court directed that you take the order of this court, go before the authority, bring it.
Okay.
The order dated 11/12/2020. That was there, and they have brought it, that's all. The relevant part, you are allowed to get that, you have brought it. But
Yes.
whatever is there, they have just.
And we have the photocopies of the marks obtained, the categories of the candidate.
Just a minute, please.
Yes, but yes, not so, they are the written exam. That's there.
Your affidavit is also not properly placed or drafted. Your reply to paragraph 7 is very vague.
Lord,
If you are contending that there was no materials to show that she was indeed belonging to or made any claim to be considered as PH category, you should have stated clearly in the affidavit. You have rather you have stated that she applied as PH, but it doesn't come under the 3%. There is no vacancy of 3% of 20. That is a wrong interpretation. At least one post can be there. Okay, anything else?
like there, Lord.
No,
but
that we have
yes,
taken note
this
of.
is the main difficulty, Lord. But
Let us see what we can do. Okay, we'll
and subsequently there are recruitment process, but she has participated. So it's not her.
what was
Lord.
her age at that time?
It-
What was her age at that point of time? he was 32.
Yes, the petition was well in the age. Age category, there are subsequent requirement of sorts. Guarantee is not that, writ petition also
So,
taking the
I,
fee of
well,
his son of, you are
that
filing
cannot
writ
be a
petition
ground
on
for them.
lordship. They are seeking this as
There
a right
cannot be-
lordship.
That cannot be a ground for your court.
Nothing can be guaranteed nowadays.
Yes. Nothing.
Whether will exist tomorrow is not, there is no guarantee.
Exactly.
What we can see is, that this moment something is there, next moment. This is how people values are changing. This is how the things are moving. And the fact that there was some investigation by the vigilance, that shows just it speaks a volume. How things went.
Okay, we'll pass, we'll consider. Heard. Sri K.K. Mohanta, learned senior counsel for the petition, assisted by Sri N.M. Hazarika for the petitioner, full stop. Also heard M.S. M. Bhattacharya, learned additional senior law advocate, Assam, who appears for all the respondents. The hearing is concluded and judgment is reserved. We'll try to give it as soon as possible, maybe latest by Monday.
Yep.
Yeah, but
Even cases. Implement of. Dispose of it.
Item 8.
Item 8. Mr. Sahewala. Mr. Rahman is waiting since long, which matter? We can take up item 13. 13 tomorrow. Thirteen.
Reading from department page.
R6 is finance department.
Yes.
Who is R6?
Yes, finance department.
Finance is R6.
So they have filed affidavit.
Just a minute.
So
Just a minute.
finance department, they have filed the affidavit on 26/3/2020. So then taken by the finance part and it's then taken by the respondent. So the contract.
6 is Director, Finance, Economic Affairs.
And got the,
Okay. Where is the finance department? Madam, can you have Mr. What is the matter, Mr. Rahman?
method of the, all the retired employees of the municipal board town. So
Okay.
they are all retired. So their service is not regularized. Then they have, as per not regularized, they are not entitled for pension. But there is a cabinet decision taken by the government for granting them relief.
The
So-
issue is with regard to the pension, post-retirement benefits
But-
of retired employees
Employees of
of
the
municipalities and
town
boards.
committee and municipal. board.
Okay, that
So
is the,
cabinet decision was taken, but there is
Okay.
cabinet.
Mr. Bharpajari will be appearing for the finance department.
Fine.
Okay.
Affidavit defined, not here.
You have admitted? Okay. Why, what is the problem today? We have time, whole day we have. At least till 3 o'clock.
They have filed affidavit also.
19 matter, we don't like to adjourn unless you have a serious difficulty, which you don't seem to have. Mr. Rahman will take some time in making his submission. By the time you pull up your socks,
They call retired employees. It's subject.
19 matter, we should, I think, make an endeavor. We should not adjourn matters of 19. Tomorrow. Tomorrow. 19 matter. 2004, 2024. 5 years have gone. If it is 5-year-old, there is a red mark. So we have to get rid of all the red marks. Tomorrow. No difficulty tomorrow.
Difficulty there, no doubt, but
What is the difficulty? Tell us.
difficulty because one is Ramjan.
Today, even today was
sec-
Ramjan.
Second is I'm
Today you go home and then take rest. Come prepared tomorrow. We'll try to have it your
Tomorrow-
matter as early as
tomorrow,
possible.
the first
I will have it as early as possible.
as early.
Yes.
Okay, great.
Kali ki bar, Kali
So,
Thursday, no
okay,
Hyderabad.
but
We may have it before 11 o'clock. If
Got
maybe even the first item. Mr. Borpujari be here. Okay. On the prayer of Sri R. Those Sri Her Sri H. Raman, learned senior counsel for the petitioners. Full stop. However, Sri R. Borpujari, learned standing counsel, finance department, has prayed for a little accommodation. Full stop. The state is also represented by MS M. Bhattacharya, learned additional senior advocate. Full stop. Para. In the interest of justice, in the interest of justice, matter is adjourned to be called again tomorrow, i.e. date. Sorry, Jagdish.
okay.
But be here at 10:15, we may have it as the first item. Tentatively, you are saying.
Good.
Depends if there is any motion, then we'll finish the motion, then we'll have it.
Item 8.
Huh? Oh, 8. Oh. 8, yes, where, Mr. Sahewala, I think. Sahewala. Normally, somebody from his office is there. Mr. Day, you are here, item 8. Other side,
That is already expired.
what was the issue involved?
There is contact, but site engineer,
With the State Bank of India.
State Bank of India.
Okay, thereafter,
Right.
what is the claim?
For reinstate.
Reinstatement. Okay. Okay. Be here tomorrow. If tomorrow the same situation persists, we'll dismiss. But we'll not say anything on merits.
Right.
Okay. None appears for the petitioner on call. Para. Sri K.K. De, learned counsel, representing the respondent State Bank of India, has submitted that perhaps there is no existing cause of action inasmuch as the petitioner has expired. Full stop. He has also informed that the cause of action, that the claim of the petitioner who was in contractual service is for reinstatement, which perhaps cannot be considered at this stage. Full stop. Para. Be that as it may, and in the interest of justice, let a further opportunity be granted to the learned counsel for the petitioner to represent. Full stop. Para. List tomorrow, date.
Right.
Full stop. It is however made clear that in case of further default, comma, this court would pass necessary orders.
Item time.
Time being 18 matter.
So that's not, so there's clear order, but my print is not equivalent to it. It's after the petition, so that certain print.
This is not applicable.
This is not for type.
You talk to Mr. Mazumdar, if
I've talked.
then we can have a date. We are not passing any orders now. You talk to him, then inform this court. Even if Mr. Mazumdar is not there, we can have a date after the
Sure.
immediately after the Bihu
Sure.
vacation. একটু পিছত order pass কৰিম, তাত মই note কৰি থৈ দিম।
Where
Both are called for document.
There's the order on 9/10/2023.
Because they are replacing the records, they are switching documents. So setting up,
What is the matter about?
But the issue related to promotion. There is a case, my lord, where his medical fitness was in question, but then my case was that, my lord, the injury that I had sustained for not in shape one was the injury that was
When
attributable
can you
to
get the
service duty.
records?
after the petition got
19 matter, we have to
lodged by
fix a date.
because old matters got, old record
6/2. 6/2 was the last date.
got
Sufficient time has gone, almost
Got-
2 months.
Yes.
The order dated 6/2/2024 reflects that Sri S.S. Roy Learned CGC was to produce the records, which was directed by an earlier order dated 9/10/2023.
Fine.
9/10,
got
para. Sri Roy, the Learned CGC, however, informs that the records are yet to be obtained and accordingly placed for some time. Full stop, para. As a last opportunity, further time is granted for production of the records. Full stop. List on 22nd.
Got
22/4.
Right.
22/4, if the records are not there, we'll go ahead.
Such my lord. Because there are 2005 problems not there.
Then
Otherwise, there are other
Okay.
medical reports which reported.
you come up with the explanation that two old records not being able to trace out, or
Sure.
maybe those have been destroyed or whatever.
got
But you cannot just hang like this.
15.
Is, my lord, again related to promotion. This is a case where, my lord, the 5 ACRs that are to consider for my promotion.
Mr. Chakraborty, we go for the final disposal.
My lord, I actually have a that if that can be clarified. But I have said that in another similar case, Lord, we should notice, and in the meantime, in that case, my lord, compliance has been made by not considered, but happened in a fact that if I do some extraneous service within the department, sir, that if I am not appointed in a battalion and I am put in the intelligence unit, my ACR in the intelligence unit was not taken in fact. My lord,
That is the extra regimental duty.
that, my lord, was interfered with in the Meghalaya High Court decision. Subsequently, in some cases that are pending here, my lord, cases have been considered. So if that,
Let me take instruction.
if that is the.
You are only seeking consideration of the services rendered by you, not in your cadre, but for the services which you have been directed to perform with something
That is
connected.
his own request, Lord. Because
Whatever.
you want to stay at Shillong. When the
Doesn't
unit was
matter.
at Manipur.
Whatever we.
No, doesn't matter. It is not
I'm
the
serving the
case that-
Assam Rifles anyway.
That is about the police.
No, see,
Anyway, I will take
see,
instruction. by the-
he is on his own request. If he's staying in a particular place, he may not be entitled to some seniority purpose or something else. But so far as ACRs are
No,
concerned,
Lord, the record of insect, that is the policy frame. Here, Lord, the extra regimental engagement. That he is a warrant of, not a Havildar or a Jawan. He is well aware of that.
no, but okay, that point we'll consider definitely. But what Mr. Pathak is trying to say, impress is
Similar
that,
case has been.
yes,
Let me
disposed
take
of for
that.
some notice issued as
Alright.
per which it has been
Let me
considered.
take.
Okay.
Consider that, in fact, in Meghalaya High Court, that particular aspect.
Point 3B Pathak, learned counsel for the petitioner, whereas the Respondents Union of India and others are represented by Sri B. Chakraborty, the learned CGC. Full stop para. The short point involved is non-consideration of the promotion of the petitioner to the post of Naib Subadar, within bracket GD, which has been published wide order dated 12/6/2020. Full stop. It is the case of the petitioner that in the concerned DPC, comma, his ACRs were not taken into consideration for the period 15 November 2015 to 14 December 2019, when he was posted in the Assam Rifles Field Intelligence Unit. Full stop. Tera, Sri Chakraborty Learned CGC has submitted that the impugned action is supported by certain instructions and therefore may not require any interference. Full stop. Tera.
Record of instruction.
Sri Pathak, the learned counsel for the petitioner, has however clarified that such instructions have already been interfered by the Honorable Meghalaya High Court, and also in certain similar cases pending in this court, comma, after issuance of notice of motion, comma, the incumbents in those cases have been considered. Full stop. Para. Sri Chakraborty, the learned CGC, accordingly waits for some time to seek instructions in this regard. Full stop. Para. In the interest of justice, comma, the matter is adjourned to be listed on 26th of April to enable the learned CGC to seek instructions.
Sixteen.
Yes, 16. Government, madam, what is this?
Matter about the section of the candidate or Anganwadi worker. Not the private respondent has selected and appointed, but the petitioner, they are not that allowing her to join because they are telling she is not that qualified as per the petitioner. But we have report that the petitioner is student not.
Is
Because
a-
she is student and
Pet-
pursuing her graduate post-graduate. As per the sort. Student can be upon criteria that they are taking regarding qualification. Not. That's private. The criteria.
Who's appearing? Item number?
Yeah.
A. Ali, M. Khatun, D. Deori. None appears for the petitioner on call. Para. MS M. Bhattacharya, learned additional senior advocate, however, submits that the petitioner is a student and is otherwise ineligible to be considered for appointment to the post of supervisor, Anganwadi
Lordship.
worker. Anganwadi worker, full stop para. Be that as it may. And in the interest of justice, that.
Helper, Lordship, Anganwadi helper.
Anganwadi helper, huh? Be that as it may, and in the interest of justice, let another opportunity be granted to the petitioner to make representation. Full stop para. List on 5th, 5-4, full stop. It is however made clear that in case of further non-representation, comma, this court would pass appropriate orders.
1917.
Reading the Oba, I am ready for both. Is that Marat I was joined as the electric
Public Works? Can take for final disposal?
second affidavit is also.
Okay.
Petitioner was appointed as an electrician, my lord, in the year 1996
Where?
in the department of, my lord, engineering department of PWD,
Electrician.
electrician. He was holding a degree of a diploma. Then, my lord, during in service, he opted for a study leave. Study leave was sanctioned, and he obtained the degree of a electrical engineer from Jorat Engineering College.
When?
My lord, in the year 2005. No, 2005 was the study leave, and my lord, and he passed in the year 2007. Annexure 6, page 39. July 2007, he passed the service of degree of electrical engineering.
Jorhat Engineering College.
He is Jorat Engineering.
Why, how in 2 years?
My lord, because during that time, my lord, I think it was 2 years.
Engineering degree. What are you
Because
saying?
he was already holding a diploma, maybe that was the
No, is there any concession or exemption?
maybe
Diploma holder.
that I don't know, but he obtained the degree.
Can a degree be obtained in 2 years, engineering degree? Even, is there any exemption for a diploma holder? We do not know.
My lord, the certificate is at page 40, and
Okay, that is not the issue otherwise.
Not the-
Okay.
he passed the engineering college, engineering degree. Since then, man, till today, he is holding a post of electric because they don't have any service. Then, my lord, in 2000, my lord, 15, there was a draft service tool prepared.
I think we have decided one of the matters.
Your lordship has heard this matter. Then, my lord, for a considerable period of time.
No. We have decided one of the matters. Okay. Maybe that is what we remember vaguely.
My lord. So there was a draft service tool where they have stated the electrician.
But one matter I think we have heard like this. Some
I
Bormon,
remember this matter was to your lordship for
some Bormon, but not, okay. Okay, yes. What has happened thereafter?
then, my lord, this draft service tool provided that they will be encouraged, there will be a promotional to the post of junior engineer.
Draft service rules.
Draft service tool. And on that basis, there were some vacancies were there. So there was an interim order passed by this court that one post will be kept vacant for the petitioner.
Which date?
My lord,
Which date interim order?
my lord, that interim order was passed 1/2/22.
1, 2,
22.
22. Okay.
My lord, now the government files an affidavit in the year, my lord, 2022, where they have stated that that particular service rule has become, draft service rule has become obsolete, and they are preparing a new service rule. And because there was a direction from this court in a writ petition to dispose of my writ petition, they have stated that, my lord, there is no prevailing law provision for promotion for the post of electrician, non-gazetted post to junior engineer in the Assam Engineering Service. So, and Assam Technician Establishment Service Rule is at draft stage, yet to be finalized. That was in 2020. And that
2022.
in 2020, they have said is at the yet to be finalized.
Affidavit you are filed in 2022 or
22, 22, but they have annexed one document where they have stated in 2020 that there is no scope for electrician to be promoted to junior. That is the ex-cadre, and the junior engineer from where the service rule starts. And my lord, and they say that that particular service rule was at the draft stage, yet to be final. That was the document of 2020. But my lord, in the affidavit in paragraph 3, they have stated that draft service will become obsolete. So we are going for a new one. So that service, draft service will go. Well, then we file an affidavit stating therein, because that was previously a statement also. There were 3 some persons who were ex-cadre. They were section assistant, electrician, and others. They were also allowed to, they were considered and encadred, and they were given promotion, and they have retired as executive. They were around 3%. By an affidavit, we have brought it into record. Previously, it was in the my lord, synopsis. Then, my lord, in an additional affidavit filed by them, they have stated, my lord, that in para 4, they have stated, my lord, may I read it slowly? Page
Affidavit of
95.
whom?
Page 95.
95.
Page 3, additional affidavit, page 95.
Rejoinder.
My rejoinder, my lord, with this, may I read it slowly, ma'am? The answering deponent begs to state that it was verified and found there was no incumbent, namely Bhavesh Chandra Dekar, who had been promoted to the rank of executive engineer in this division, as stated in the synopsis of the petition. However, reportedly,
You're reading which page? Which,
para 4, page
Oh.
95.
no, pages are different. Just refer to the which affidavit?
Affidavit filed by Sharat Chandra Kolita.
Not Pradeep Sharma.
No,
Sarat Chandra Kolita, yes, it is 102.
para 4.
Just a minute. By R5. Who is R5?
R5 is my lord,
Executive engineer.
executive.
Okay. Para 4.
Para 4.
At page?
Page in my, it is given 90.
At 104. Yes.
That the answering deponent begs to state it was verified and found there was no incumbent, namely such and such, was promoted to the rank of executive engineer in this division, as stated in the synopsis of the petition. However, reportedly, Sri S. Sen Sharma and Abdul Mateen Chaudhary had joined as section assistant. After a period of training, both had worked as sub-engineer grade 2, and after due course, They have been promoted to sub-engineer grade 1, then promoted as assistant engineer electrical. They joined as section assistant and not electrician, so the case of petitioner not in the similar footing with those two. But here is the case, my lord, it is not, they have never said that it is an illegal promotion, but they have said that it is a promotion. So because I am saying not an illegal promotion, because there may be a question asked by the other side, my lord, whether negative equality may give me any right on. That is why I am saying, my lord, they have considered their cases for encountering them by this Abdul Mateen Chaudhary and S.N. Sharma. And they were section assistant, and they have retired as an assistant engineer because the service rule provides from the post of junior engineer. Section assistant as such, there is nothing in this service. It is from my lord, class and cadre, it is there. And my lord, it is start academic qualification, it starts from junior engineer, then promotion to assistant.
Which
Section
route?
11 is the, my lord, for assistant engineer.
Yes.
The appointing authority shall publish the government gazette annually the number of vacancies in the respective cadre of assistant engineer which has occurred or likely to occur in the year, subject to suitability as may be decided by the selection board and by the appointing authority in consultation with the commission. An officer belonging to the cadre of junior engineer of Assam Junior Public Works such and such shall be eligible for promotion. So it starts from junior engineer. There is no question of section. And in the definition of class and cadre, my lord, at section 3.
No, they have been promoted to sub-engineer, grade 1.
Then, my lord, then
Then promoted to assistant engineer.
assistant. Sub-engineer grade 1 is equivalent to junior engineer.
Yes, so their promotion appears to be correctly done.
My lord, section assistant, that is also an expert. That is also an expert.
No, we will come back to you.
Just one point.
Yes.
Whereas both of your and lower level not those the subject that product
No, that will consider definitely. See, this is an engineering service routes.
Engineering.
The first entry into the cadre is assistant engineer.
Engineering.
No, not junior engineer.
Assistant.
Assistant engineer. The first entry into a cadre is assistant engineer. How you become an assistant engineer? There is a direct recruitment from BE, and there is also a provision for junior engineer to be inducted in these services, wherein you need to serve a particular length of period as a junior engineer and and even if you have a BE degree, then there is another concession.
My lord, I may be wrong, my lord. So, lordship promise me. May I read, my lord, 11.2?
Yes.
Subject to suitability as may be decided by the selection board and by the appointing authority.
Yes.
In consultation with the commission, an officer belonging to the cadre of junior engineer in the Assam Junior Engineering Service under the government shall be eligible for promotion to the cadre of assistant.
Yes. Yes. When?
My lord, in the manner provided in
Yes. First, you need to have possess a qualification in diploma in engineering as recognized by so and so. Number 2 has undergone the training and passed the departmental examination.
Minimum service. So, my lord, my question is the first point is junior, then assistant, then executive. First is junior.
No. Junior engineer is one of the
Criteria.
feeder cadre,
The feeder cadre.
not in the ambit of this Assam Engineering Service from 1978. The first cadre is assistant engineer here. The first entry point is an assistant engineer.
Then
A junior engineer can become an assistant engineer. A direct recruit can, engineering graduate can also be an assistant engineer.
Correct.
So
The promotional avenue is to junior, and my lord, another way is to direct recruit. There are two ways.
yes.
That is at page section 8, my lord.
See 4. 3 and 4, what we are trying to emphasize, we just forgot.
The
this one.
service shall consist of the
Please
following
first read 3, the vacancies, 11.3.
11.3. The vacancies to be filled up by promotion of junior engineer shall be so fixed that the promoted assistant engineer strength shall be 30% of the total corresponding cadre strength of permanent and temporary assistant engineer.
So 30% would go from the junior engineering. Now, number 2, again 4 is also important.
A
Read.
member of the Assam Subordinate Engineering PWD service shall be eligible for promotion of assistant engineer subject to the following condition. 8 years of service as a
Minimum
subordinate
8 years as subordinate engineer,
in the
and
first
number 2,
January, first year of the year of
Yes.
promotion.
yes.
And my lord, next is successfully undergone training and passed
Then
departmental.
read C. C is very important.
Notwithstanding anything contained herein above, subject to suitability, subordinate engineer grade 1, Assam Subordinate Engineering PWD service, on his
On
acquiring
his
the academic
acquiring the academic qualification
qualification,
as prescribed for a
the
direct
direct recruitment
recruit
shall be
assistant
promoted to
engineer. That
assistant
means he acquires B degree in the meantime.
My lord,
Then shall be promoted assistant engineer in consultation so and so.
because my lord,
Yes.
my case is that I have undergone that qualification of assistant
Or B.
B.
Yes.
B, so I am qualified for assistant. But I have been working for 27, 28 years as electrician.
But were you in a cadre under the Assam subordinate subordinate engineering PWD service?
I am not in the category. I am an expert. That is the admitted fact. That is why I am placing, my lord, this Abdul Motun Chaudhary, he was a section assistant. He doesn't belong to this Assam Engineering Service group. He was also an ex-cadre, my lord.
Let us see that that other service rule, Assam subordinate engineering. Assam subordinate engineering এই ডাঙৰ হেৰিখনত থাকিব। এইখনততো নাথাকিব, এখন ডাঙৰ কিতাপতে। Assam subordinate. Do you have that the other one?
It's the irrigation department of
PWD doesn't have such.
we follow the
Okay, irrigation. Okay,
it's not there.
you have a copy?
I have a copy, but
Abeli Kasani এই ডাঙৰ কিতাপ আছে service rules.
there not get the this section is
Is one of the cadres.
Grade 1, subsequent.
My lord, that aspect of the matter, your lordship may keep it tomorrow, my lord. I will look into it. And if they are saying, they have just asked, for the first time, they are saying that the irrigation department service, engineering service rule is there.
It's a repeated stamp.
But they have never said in their affidavit that service rule is.
Otherwise, what is your stand, Mr. Nayak?
Lordship, so far as electrician is concerned, it cannot be promoted. So in
Assistant engineer.
essential come much later for getting a promotion to the post of extent. You will have to come with your engineer. Or you will have to directly apply for the post of this if he has the qualification. Before that, lordship, you have to get 2 promotions. That's the subordinate grade. Grade 1 was substituted when has been put. So he is holding the post electrician. He is holding, I mean, section assistant.
But all
From
the,
section assistant, subordinate engineer, then junior engineer, then assistant.
my lord, whatever it is, 27,
stages are there.
28 years, they have not considered my case for promotion. Even to the next post, I am qualified, my lord, all the writ petitions were there filed earlier, they have said considered her case.
No, consider definitely, but what is the post which is available to an electrician on the next?
There is nothing, no promotional,
Then where, if there is no promotional aspect,
no promotional.
then your claim is based on what rules?
My lord, that is my, because relaxation I cannot claim for this.
See,
Yes.
if you have possessed your engineering degree, you could have applied for a direct recruitment.
My lord,
as
my
assistant
only
engineer.
thing is this, when this post has been kept open for such a long period, they have not abolished this post. Was it not a duty for them in consultation with the department to either to abolish this post or to enter this post and give me some promotion? It was some in one of the cases, my lord, I found it today, my lord, where it has said that it was a duty obligation on their part also. Because 27, 28 years, they are continuing with the same post. It was obligatory on their part to either to abolish this post or to encadence this post and consider her case for promotion. This is
Stagnation kind of a.
that itself is not the financial is not the criteria. Your lordship will look into this paragraph, paragraph 29, ma'am. 29. Your lordship will look into
Which?
Judgment 2005 SCC page 7.
Okay, we'll do one thing today. Otherwise, also it's 1 o'clock. We'll have it tomorrow. Can you bring that rule? Or Friday? Friday you are here?
Friday, my lord, I have
Tomorrow?
tomorrow.
We'll have it maybe at 2 o'clock or whatever. Because tomorrow there's a reference. Otherwise, also this court is rising early this week.
Tomorrow also there is a reference.
No, this court is rising for some interview at 3 o'clock these days. Tomorrow we'll try. But we have heard more or less. Will not take much. Yes.
Keep paper.
We have full benches in. Oh. Okay. Tomorrow it may not be possible. There is a full bench tomorrow.
On 9.
Oh. Monday? Monday is it okay? Monday, 8th. This is second bench, so hardly there'll be any. 8, 9, 10 or motion date হয়ে যাবে মোটামুটি কালির পরে চেষ্টা এখনো we'll try on 8th.
On 9th.
9th and 10th would be slightly rush.
All right.
We may be given a bail matters or not. Let it be on 8th. Heard Sri P.K. Roy Chaudhary, learned counsel for the petitioner. Para. Sri P. Nayak, learned standing counsel, PWD. However, submits that there is no separate rules in the PWD pertaining to the post of electrician, and the services are governed by the rules followed by the irrigation department.
Not like this. He is aiming from and to extend the electrician post not a cater that service.
No, no. Nayak submits. Full stop. He further submits that the rules followed by the irrigation department would have a relevance which he would like to produce on the next date. Full stop para. As agreed to by the parties, list on 8th. 8/4.
Probably.
That Roy had given some, whatever. I find that my humble submission that's not covered.
You said that similar orders are not
But-
applicable.
But that is not a similar order, the one that is not similar on the facts.
Okay, when 18 matter, we'll fix a date.
My lord.
Put the railway on a
One of the
Okay. On a joint prayer made by the learned counsel for the parties, matter is adjourned to be listed on 22nd of April.
with the okay.
18 matter, okay. We'll have it on 2nd of, 1st of May.
Second of April, first I'm coming back.
native.
Okay, for us, but I'm coming back on the first to the second.
Okay, 2nd of May.
So obliged.
May I please,
Yes.
please regarding the completion appointment of petitioner has been died on 9/4/2011.
You are in which matter? Item
18 lot.
number 1808,
1808.
Sarala Brahma.
Yes.
Okay, what is your case?
The petitioner has been died on 9/4/2011 lot.
9/4,
2011 lot.
husband died.
Husband died. He worked as an extension officer in the office of the District Justice and Commerce Department, Kookrajar. He was applied for appointment and forwarded his application on 30/6/2011.
When did you apply?
Applied lordship 30/6/2011 lot.
36.
11 and forwarded.
Petitioner applied
Yes, sir.
for a compulsion appointment.
Commission report. Accordingly, her case was considered 29/10/11 loss by DLs and
When?
by DLs
When?
29/10/2011.
29/10,
2011.
DLC considered.
Yes, and forwarded to SLC.
When? Okay, same
And
date.
what's the SLC meeting dated 3/10/2015 did not consider.
Which date?
Her case.
Which date?
3/10/2015.
15.
15.
Okay.
Agree petition file a writ petition being WBC numbers 969 of 2006 and directed the husband to consider her case in the next SLs.
Date?
That lordship 9/9/2006. According lordship, petitioner case was placed and on 18/1/2020 lordship. And that time also not considered on the ground that vacancy, lack of vacancy. That is the case.
Okay.
So that lordship, petitioner case may be considered in next SLC meeting. Example.
What is the other writ petition of 19? Similar.
So,
Why both are
purpose
tagged
is-
together?
Purpose is similar. Yeah,
No, that is okay, but
but for
cause
my
of
case,
action is similar or what?
different. That for my case, my parent mother died on 25/2016. After I have filed the application, thereafter the forest department, for the forwarders sent the deputy commission. That my name has forwarded the secretary because at the given time not there. So the department does not have power for of that matter. As on this matter, my case is pending.
So yours is a different case. First, let us then consider
Fine.
his case,
Yes.
then we'll come to your
Fine.
case. Yes,
That's although it's that's work under justice and commerce, sorry, but they might produce.
doesn't matter.
Although that's work. Address certain so if the second see shows the vacancy position, then is the case come with for the access process. The rest is only a question of vacancy. So it's the question.
Who is for BTC? Madam BTC. Mr. Abha would appear here. Madam,
Prabha was
where is he? Where is Mr. Abha? He's on legs. Okay. Mr. Barua, Sarma Barua, why do you want the intervention of the DLC at this stage? DLC had already,
Already considered.
we tentatively were thinking that there is nothing for the DLC to do at this stage. So what is the role of BTC?
Only to sort of vacancy, for example, because this matter has got under the.
See, if BTC does not place the vacancy position in the court, aren't you in a position to know the vacancy? You are the state level council.
One order, put a chief secretary to write to all the department and get.
That is the purpose of SLC. We will re-verify the
That's the
recommendation. Now, at the time of recommendation, a vacancy was shown. Now you hold that subsequently vacancy is not there. SLC can very well ascertain the vacancy position from the concerned whichever district. If it is BTC from the BTC, if it is a district from the deputy commissioner, the district level committee.
But
Now this minutes of 18-1 to 2020 of the SLC where his case has been rejected on the ground of lack of vacancy. Well, let us read that.
Page number 25 of it.
On the last occasion, why an order of the Honorable Supreme Court was referred? Is it,
The
Delay.
submit, they will put the delay.
you are Mr. Nawaz,
Yeah,
Mr. Ahmed, where is that page? Where your candidature has been rejected on want of vacancies, 18-1-2020, which page?
Page number 19,
19.
19.
Address was the effort, so not because twice we have placed for that. This case has been placed twice. So effort under the wave of 15. It has also been expired. It's a good thing. When the person dies, at that point of time, then the earlier one was. At 2009. So as for the 9, the tickets. That's why it is.
No, but the DLC, while recommending the case in 2011, they had observed that there was a vacancy where the petitioner's case can be considered. Okay. Or his case was, his candidature was considered. See, so far as the expression of want of vacancies, this has to be understood in the context of the facts and circumstances. If there are no vacancies at all, where the cases could not be considered, that is the different aspect altogether, where we may direct a reconsideration. But where the number of candidates were more than the number of vacancies, it doesn't mean that vacancies are not there. You competed against each other, 45% quota, you could not. So that will have a different connotation. Let us see where. Yes. Yes, in. Hmm.
There are around 690.
Six November. Yes, Mr. Abha, you have any role here? No, these are old matters. Oh, this is 22, the other one is of 19. Where is the DLC's recommendation, Mr. Ahmed?
Lordship, I have annexed those.
Why?
It's already SLC detected, that is why I have annexed the SLC.
It was which district?
Across.
So this Kaushik Patgiri, Mr. Kolita,
Yes.
Kaushik Patgiri is from Nalbari district.
One thing,
He is not from Kokrajhar.
this, since, okay, when Nico against the process, it can consider from the department.
No, that we understand. That is the clause that if vacancy in one department not there. But here, no, here the vacancies which was vacancy which was earmarked for the case of the petitioner pertains to the district of Kokrajhar.
Professor,
But Kaushik Patgiri has been appointed where? In Nalbari. So what happened to that vacancy? Because if you come to page 20, the chart, they have given DICC office and the district. Nalbari is Kaushik Patgiri and Kachar is Abhijit Deb. That was necessary. Do you have the document with you otherwise? Yes.
Which poem?
No, we are not going into that controversy.
So at that point, of time, this SLC, they have all whatever techniques wherever. And then after that, like maybe that is the reason that's why they have upped the vacancy. Like, so that's what it is. But as far as like substance, sir, that's at but at that point of time, that is in 2009,
No, have a look at this. His consideration by the DLC. The last portion of this page. First read the chart. Last portion.
General manager. He can convert the shut down for document of the 20% all, but they have one post
One post is found vacant.
that
First for the second.
It is not that recommendation has been made without ascertaining the actual
Right.
vacancy. They have ascertained the vacancy first, one
provided
post,
the vacancy.
one post. Then said that in that vacant post, she can be accommodated. or-
Completed, of course. But there's one. The first. The first sentence or the second
Yes.
first sentence also perhaps they have not been.
Where is the 3/10/2015, Mr. Ahmed?
It's the second assessment.
Where is 3/10/2015? Have we annexed?
No, Lord.
Just not attack.
Where is the judgment of 9/9/16? Why didn't you put the documents so that we can?
The position is not clear. On what chart he has been like.
They have not annexed the High Court judgment also, order also.
That was. Perhaps it
You are
was-
banking your case entirely on the earlier direction for reconsideration. You have not annexed it.
Around this could be of another instance.
This time only this.
হবো না, হবো, হবো। What is this? This, how can I read this? Can you read this?
I collect from the full line.
Where is the reference to the High Court case in your writ petition? Paragraph 8.
Yes.
Yes, Mr. Sharma Bro, have a look at this. Mr. Kolita. See the writ petition number. And see the writ petition number in paragraph 8.
Oh, this is different. The 969 of.
Yes, Mr. Ahmed.
Not clear to it.
You have not annexed number 1. You have given another copy. আর এখন আছে নাকি? Mhm. That it is in fact 969, it has a relevance. That is based on the 111116. That is why maybe both are together. That we're trying to figure it out. For BTC, which is the final authority?
Secretary.
Central Selection Board. No, SLC,
not
no, for
SLC.
BTC,
Because the BTC under principal secretary.
Principal Secretary.
Yeah, different.
What is happening?
Okay, okay.
What is happening to him?
No, I was just saying the secretary of the SCC, secretary
Okay,
of the.
okay.
I'm talking about SLC. Why are you talking
Come on,
about this?
don't.
It's already temperature is already high, Mr. Sarma Burwa. This temperature is already high outside, so don't increase the temperature inside the court. Okay, 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 that is-
This is asking about BTC.
Okay, this is small issue.
I didn't get the communication. I was addressing your lordship. Who is he tell like this?
In fact.
Okay, let's cool down, cool down. Cool down, there's nothing to be.
I'm a party here. What note?
So far as the BTC is concerned, the earlier order passed in 1116, which was also made applicable to 969,
Yes.
says that there is a central selection board headed by the principal secretary, BTC. So SLC perhaps will not have too much of a role here.
DLC headed by principal secretary.
No, not DLC.
Yes. Yes, sir.
Have a look at have a look at this. What is the meaning? Hey. Is to is sent to the. What is the meaning of this? I have a look.
Secretary of
No, no, is there a difference between consideration of a case under for compassion appointment for district vis-a-vis the BTC? Or is it the same? For a normal ordinary case where a compassion appointment is considered,
Right.
first it goes to the district level committee
Yes, yeah.
and then it goes to the state level
Yes,
committee.
that in case of
Now in BTC, what is the rule?
Yes, in case of BTC, as far as I know, Lordship, the principal secretary of this and all these Kokrajhar, Sirang, all
Okay,
this number, he assumes the power of DLC. And all the application for all that.
that is the idea which we had, but what is the direction in this case? Direction is different.
That-
Direction, court has assumed that so far as BTC is concerned, that particular expression has been used, that is, that plays the role of the final authority.
No, it's not. I've seen the order.
Mr. Abha, have a look.
Because after this, it has to go to the chief secretary.
That is the normal
Yes, sir.
procedure.
This order, Lordship. Is the final order.
No, we are not on that. Transfer
Otherwise-
subject, we are on normal subject. We are on the final authority. Who is is there a difference in the final authority so far as BTC is concerned? We don't think so.
Not in the.
Instead of district wise, it is sent by the BTAD, by the principal secretary, she sits as the chairman, then it is sent to the state level committee.
Oh.
But what is the what is the direction?
Is that when I've seen that
Central board or something, some. Please read the last part. Please read the last part. Please read, please read.
The petitioner's application has already been considered earlier. Principal Secretary meeting self-furnished consideration.
I've not found because this sector selection board.
Now what to do here?
I think was
See, Kaushik's Patgiri's consideration was for Nalbari district. His recommendation was for Kokrajhar district.
Kokrajhar. Thing is that his vacancy cannot write.
Mr. Abha, you take instructions that the vacancy which was mentioned in the earlier DLC of 2011, it was filled up by whom and by what process? If it is filled up by another process where it has been filled up by compassion and appointment, then matter may end there. Because petitioner cannot have an indefeasible right to be appointed alone. Some others may also be considered. But whether that vacancy has been filled up otherwise or by compassion appointment. Okay, please write. This is the second round of litigation instituted by the petitioner with a claim for appointment on compassionate ground. Full stop. Briefly stated, comma, the candidature of the petitioner was earlier considered and recommended by the DLC vide an order dated 29/10/2011, wherein a vacancy in the DIC Kokrajhar was also mentioned. Full stop. However, on 3/10/2015, the case of the petitioner was rejected by the SLC. And accordingly, writ petition 969 of 2016 was filed by the petitioner, which was disposed of by the order dated 9/9/2016 by this court. Full stop. As per the petitioner, comma, there was a direction for consideration of the case of the petitioner in the next state level committee meeting. Full stop. Para. However, in this petition, the documents pertaining to the earlier recommendation and rejection, including the order of the court, have not been annexed. Full stop. Be that as it may, comma, the SLC in its meeting dated 18/1/2020 after consideration of the case of the petitioner had observed that appointments cannot be made due to lack of vacancy. Full stop. Para. Since the district level committee in its meeting dated 29/10/2011 appears to have mentioned about a vacancy in the office of the DIC Kokrajhar, where the husband of the petitioner was working and had died in harness, comma, Sri S.R. Rabha, learned Standing Council BTC, is directed to obtain instructions with regard to the FAT of that vacancy, which was mentioned by the DLC in its meeting dated 29/10/2011. Full stop. Para. List. Yes, when should we fix this? List on the list on 3rd of May. Is it okay? 3rd May? 3rd May. And the second one?
The date is of 2016, Lord.
Which date?
The date of 25. On 25/2016 for the date
25?
2016.
Yes,
I filed application on 4/5/2016.
yes.
Thereafter the engineering department, my civil department,
Public Works.
forwarded my the DLs. Then when the DLs the recommendation, the tell him that against
DLC could not recommend.
my DLC the minutes as well as my forwarded secretary
Secretary of?
of my PW department.
That means it was rejected, no vacancies.
For my part, is no reject got mentioned.
No, but is it written that there is no vacancy?
On page 23 is not ready.
23.
Right.
Yes,
Serial
please.
number 6.
What is your name?
Vishwajit Kolita.
Vishwajit Kulta. 23.
Married.
Yes, please.
The proposal was discussed and seen that 5% is better than in point for appointment from count that allowed considered app and CLC said saying the proposal that but at their level as per amendment number 1. Here from the side letter dated 87/18 page 33 annexure 8.
Page?
Page 30, annexure 8.
Yes.
The DLC Deputy Commissioner forwarded my name along with the DLC minute to the Secretary to Government of Assam Deputy Department on 18th May for consideration of my point. Yes.
Minutes submitted. Yes, where is the minutes of meeting?
There, minus of seven committees, minus of page 20. As per Secretary of State. So far,
22.
22 is the first committee minus.
That we have already seen.
Thereafter, my matter is pending for the matter. Secretary to the Government of as on. Either my case is considered not is some yes, nor any conflict was made about the regard about FTP file.
See, the letter at page 33 is only a consequence of the
Yes.
finding
have-
of the DLC. That matter needs to be sent to the administrative department to explore the option of clause 15.
Right.
Thereafter, matter has not proceeded. That is your case. Yes.
Yes.
The department is for the
Yes, Public Works Department is a party.
Right.
Where? Who's? PWD who is appearing?
whole part.
Name shown.
3 and 4, my lord.
Name is shown or not?
3 and 4, 6 and 7.
For department. Anyway, so you have here for. Hold on.
Mr. Dinath is there. Dinath is also for Public Works. R8 is whom?
Right.
Who is R8?
But it was hot.
My lord, I ordered it at 10 and 20. Personal report.
Personal department was because to file one debit. That's cost.
Personal impeded, I ordered it at 10 and 20.
No, file affidavit.
High level.
File debit. It's not.
My lord, paragraph 8.
No, but we need the assistance of the PWD council. Okay. The case of the petitioner, briefly stated, is that on the expiry of his father on 25/3/2016 while on service, the petitioner had offered his candidature for appointment on compassionate ground, full stop. However, as there was no vacancy, the DLC in its minutes, in its meeting dated 21/3/2018 had proposed to remand the matter to the administrative department to explore the option of clause 15 of the office memorandum dated June 1/6/2015. Full stop. Consequently, a communication was issued by the Deputy Commissioner of the district as the chairman of the DLC to the Secretary PWD on 18/7/2018. Full stop. It is the case of the petitioner that thereafter no action has been taken and therefore this writ petition was filed in the year 2019. Full stop. Though the personnel department, which was subsequently impleaded has filed the affidavit in opposition, comma, the matter regards and requires a clarification by the administrative department, i.e. PW department. Full stop. Let this case. Is there any PWD council here? No. We'll have it on Friday. You give a copy so that
Fine.
that this case, this court has noticed that standing council PWD has not been reflected in the cause list. Para. Accordingly, list this case on 5/4/2024 by reflecting the name of SC PWD in the cause list.
Right.
Twenty-one.
Yes. Was engaged as a master work in the year 1992. The authority of the assistant executive PWD is subdivision this. My lord, he demands that all these similarly situated persons were in the meantime regularized by the order that will find at Annexure 4, page 18. But 88 persons have been regularized. But this is language.
But now after open DAS, where is the scope?
My lord.
After open DAS 54, where is the scope? Yes, who is appearing here?
I have received not, but in a small scale issue involved,
Now, after open DAS, where is the scope? He'll get benefit of open DAS.
and he's getting the benefit.
He'll get the benefit of 54. Was it 54 or 15? What was it? 45. Oh. You have already surpassed the age of superannuation.
No, no,
You are still in service.
I'm still in service.
You'll get the benefits. But regularization and
My lord, the other persons have been regularized,
those,
my lord,
when was it done? After open DAS?
my lord. After, not after,
Well,
it was
that is-
2005.
Open DAS have taken care of all this. Some persons have got, but that will not mean that it can be a policy decision. And in open DAS, which we were discussing the other day, it was considered by the department from the state that this is something which we would offer. And therefore, it was not a direction as such.
If my understanding, Lord, if regularized or minimum pay scale, these are alternate. Once you are receiving the minimum of the pay scale, regularized,
And I think as per open DAS's directions, you'll also get after your retirement, you'll get post-retirement benefits. What is it? What is the direction? Last part? Not retirement, but minimum. Then something has also been said.
paragraph. But term benefit has no consequences when like pension, that has been denied.
What is the last paragraph?
Not important for this reason, we are of the view that in the fact situation of the case, mastered workers, workers workers, and casual workers are not entitled for regularization of their services with consequential benefits such as pension.
Yes. Then read. Please read.
We accordingly subject to a direction in paragraph 22 of the judgment, allow the appeal and set aside the impugned judgment and order dated 2012-2014 passed by the Senate.
Oh, there, what was in 20, the paragraph mentioned?
Paragraph 23 is not, it is however heartening to learn that the state government has agreed not to terminate the master workers and similarly placed employees
Hmm.
working since last more than not in sanction till their normal retirement, except on disciplinary ground on or down of criminal law. They would not be terminated.
Hmm.
The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive step.
This was the step. This is the step to enroll them in some of the health benefits. Insurance. Okay.
That they are getting. The only difference, my lord, this is not a case of 10 years. But we are working since 1990. And all the P93 employees only, April, my lord, the 1st April 1993, my lord, they were regularized. I am also of that category. And they are regularized.
Where is your document?
My lord, the, my lord, annexer, annexer at page 18, that is the order of regulation.
No, your document.
My lord, my documents, lordship will
Page
find
15.
page 15.
It's a
Page
certificate,
15.
it's a certificate and
Yes, my lord.
certificate was
Yes, my
issued
lord,
when?
at that time, initially engagement without any appointment.
When is the certificate issued?
My lord, that was issued, my lord, 2006.
2006.
Then, my lord, there was another engagement, my lord, in continuation of the earlier engagement. There is another, my lord, order, my lord, at page 16.
These matters have been taken care of by the division bench.
Bench has sought all the petitioners prior to that.
Covered. Cannot help. Can you give Kupendas? Heard Sri A.R. Sikdar, learned counsel for the petitioner. Also heard Sri P. Nayak, learned standing counsel, Public Works Department. Full stop. Para. The facts projected in the petition is that the petitioner has been serving as master roll worker in the Public Works Department since 14/3/1992. Full stop. In this connection, comma, a certificate dated 24/1/2006 has been annexed to the writ petition. Full stop. It is the specific case of the petitioner that while 88 numbers of similarly situated master roll laborers were regularized in their services, wide an order dated 5/10/2005, comma, the petitioner was left out. Full stop. It is submitted that the beneficiaries of the said order dated 5/10/2005 were engaged prior to 1/4/1993, and few of them are also junior to the petitioner. Full stop. Accordingly, comma, the petitioner has paid for regularization of his services in terms of the benefits given to similarly situated persons vide the order dated 5/10/2005. Full stop. Para. The contention of the department represented by Sri Nayak, on the other hand, is that the issue has been settled by the Honorable Division Bench of this court in the case of State of Assam versus Upendas, reported in 2017, 4 GLR 493. Full stop.
It's with that paragraph 14.
Sri Nayak has referred to the issue which was under consideration as reflected in paragraph 14 of the judgment. Full stop. The directions passed by the Honorable Division Bench while allowing the appeal are extracted herein below. Paragraph 22-23. Full stop. This court is of the considered opinion that when the issue involved in this case is squarely covered by the aforesaid judgment, comma, there is no scope or requirement to reopen the said issue. Full stop. Accordingly, it is directed that accordingly, this writ petition is disposed of by directing that the observations made by the Honorable Division Bench in the case of Upendas would be squarely applicable to the case of the petitioner. Full stop. Writ petition accordingly stands disposed of. निकाल लीजिए हाँ। Yes, you take this back. ये निकाल लीजिए हाँ। लिख लिया ये तो लिख लिया ना? Yes, next.
22.
52 मतलब the picture of physically disabled person. They have participated in selection process, and there are some grounds, vital grounds, in challenging the selection process. First ground, is that the selection list is shared, based on category and department. That was not possible. Then, the selection was throughout your state, and different districts awarded marks. The assessment was different.
Without prior to 31/1/23, 31/1. And then
Are you aware?
No, my lord, we are aware, my lord. That is one part. My lord. There are some other irregularities. We have challenged that one.
Hmm?
that is the next and
My-
the last and then 31.
You appear for whom? Guwahati University.
Let them file affidavit, my lord.
No,
We have challenged as a whole the selection. They are saying that, my lord, there was
Mr. Fukan, you can file an affidavit and place this on record. You may not annex this whole selection list. You make a statement in the affidavit, have a copy, place it on record. And in that case, he also gets a chance
my lord.
to know what is your stand actually,
Right.
because you are contending that it has become infructuous. If it has become infructuous, then it has been infructuous from all point of view. If there are any existing issues which may require some consideration, we'll consider, otherwise we'll close this. Heart 3 AR Sikdar, learned counsel for the petitioners, full stop. Para. Yes, ma'am. 24 is a private respondent. Yes, what do you want to say? You want to submit anything? Okay. No, it's that you are otherwise entitled to. Please get give them a. But
Well-
along with the notice, didn't you get a copy? Why? How can it be?
On 12/4, that passed an order saved paper pub-
Or through paper publication? Okay.
Initially, we served, my lord, non-res
Okay,
they have not
okay,
received.
okay. You will get a copy.
My lord, I'm just now I'm
Okay,
giving.
okay, we'll pass on. Okay, had 3 years in the land council for a petitioner. This court on the last occasion, that is 15/2/2024, had recorded that service upon the private respondents was complete in view of the paper publications. Full stop. Para. Today, what is your name? Miss J. Busha, learned counsel for respond number 24. Sri R.A. Mazumdar, learned counsel for respond number 43. N.H. Laskov for respond number 37. Madam, your name? Azaz Gupta for respond number 31 have appeared. Full stop. have appeared, appeared, full stop, para. Sri Sikdar, the learned counsel for the petitioner undertakes to serve copy of the writ petition along with the documents to the respective counsel for the respondents, full stop, para. Sri P.J. Fukan, learned counsel for the Guwahati University, however, submits that that due to subsequent development, comma, the writ petition has become infructuous. Full stop. Let an affidavit be filed in this regard, for which 4 weeks' time is granted. Full stop. The other respondents may also file their affidavit during this time.
Biplab.
Yeah, provided by the DLC itself, but my dot itself was that it had special code, but the code found that without recommending just forwarded to the SL. So this is granted by the DLC. Now this time that DLC rejected on the ground that he was a minority at the time of the death of his father. Because I have annexed the code of bench. Page number 38, the DLC is recommended.
30?
Page number 38.
Yes, who died?
I got father.
Father, when?
Father 17/17/2007.
1/7/2007. Father died.
Yes.
Okay.
Now the page number 40 is the relevant code
40.
code, the DLC method. There it is, but
40, yes.
40 very pretty.
Yes.
My lord, considering that
What is your name?
my
Pankaj
lord,
Bhuya.
Pankaj Bhuya.
Yes.
So while considering the honorable Guwahati High Court ordered it for in the previous the application of the petitioner was part of by the DLC.
What is this order of 39?
Yes, this my page number 34, my sorry, my
What happened? 34. This is, yes. First petition you had
Yes.
filed.
page number my lord, 21.
No, 34 you had said.
In
39.
this case, the notice was issued, my lord, with the direction that the petition will not be part of
29.
consideration. So, my lord, that was placed before the DLC.
No, why don't you go chronologically? Your
Page
father
number
passed
33,
away
yes,
on
yes,
1/7/2007. Thereafter, what happened?
yes. The petitioner applied, my lord, and his case was not considered for which will
When
pay
did you apply?
on 6/8/6807. After for non-considered,
Applied for compassionate ground.
yes, sir, compulsory.
Okay, then
Then will page number 15 here approached the full court for non-consideration in the year 2011, my page number 15.
is
This one
15.
court, page number 15,
9/1.
9/1/12. Disposed of the state petition directing as per Pachitranjan case to consider
Be considered. Direction for consideration. Thereafter,
then
what
he
happened?
my lord communicated the order below page number 17,
Okay,
but it was forwarded by the superintendent, page number 19, additional deputy commissioner to the superintendent of police. Lakhimpur, not Lakhimpur.
Hmm.
And thereafter, my lord, it was not considered for a long time, though he approved to cover a location. but it was not placed before the DLC,
Hmm.
for which he again approached the Honorable Court, my lord, in 2021 with WBC 4287, page number 21. Page number 21. This Honorable Court issued notice and in the page number 22, last paragraph, my lord, held that, my lord, pendency of the writ petition would not be a bar for consideration. Page number 22. So during pendency of that writ petition, the case of the petitioner is placed before the DLC. Page number
Just a minute, please. 22 is the order. 3921.
3921.
Yes.
Yes, my lord. Then, my lord, the DLC considered, my lord, page number 24. Relevant page 28. That's, my lord, Pankaj
What is the
Bhuya.
meeting date? 8/11.
Yes, 811 DLC.
Page.
Page 28. Last 24 is the petition of Pankaj.
Okay. Yes.
So here, my lord,
Comply.
it is
Com-
mentioned, my lord, that complying the honorable court's order, it is so and so. The proposal was placed in this DLC and decided to forward to the SL for further consideration. Is to be mentioned here that in the verification of documents, it is found that the petitioner was a minor at the time of death of the deceased person. So it is recommended, it is forwarded, my lord, but no mention of recommended. But that is recommended.
Okay.
Then, my lord, SLC, page number 29.
Yes.
SLC, my lord, page number 30, rejected, my lord, on a different ground, not on minor. Page number
At page.
30, 30, last column.
Yes.
It is mentioned that the late submission of ticket. So no mention of minority. For which the petitioner had approached this honorable court, my lord. Page number 34. Page number 34, my lord, this honorable court in paragraph number 4.
Where is the original of this 10-2? Pankaj?
Yes, name of the Pankaj Bhuya, my lord. Name of the Pankaj Bhuya.
No. Page 29 is the type copy. 29,
Original, my
30.
lord, page 33, my lord. Page 33.
33.
Page 33, in the middle, my lord. In the middle, Pankaj Bhuya, 106 is not legible. Serial number 106.
Four. How could you read this? Rejected
Rejected, my lord.
as
Uh,
per OM for
For late submission, it is, my lord, so illegible, but it is discernible, my lord.
how do you know it is late?
My lord, first it is written rejected
as per poem what in the first line. Sir.
Yes, then
In the second line, late word is there first. Late submission of application. Application in the third.